File a mentioning memo.
Lordship, this is a SSC teachers recruitment.
Whatever it is, file a mentioning memo. It's a pending matter.
It's no, yeah, I have filed certain AMEs for on behalf of some cancer patients. Actually, the exam is on 7th.
File a mentioning.
Okay.
Wait, please, Your Lordship. Lordship, with your permission, may I mention item 77, which is listed today.
77 is taken up after the first 9 items.
Yes, Your Lordship. The Lordship, there's a personal difficulty for the senior Your Lordship. Madan Kumar Mishra is the leading counsel, my Lordship.
If you don't want to argue, then we'll give you a date, but it will have to be after some time. You can't file a fresh matter and then say the time.
The fresh matter, it has come up in supplementary list.
Sorry.
Lordship,
You want to?
maybe on Friday.
No, that is what we are telling you. You don't get the choice. Once you ask for
bereavement in the
matter is listed today for a reason. It's been added by way of a supplementary list. We have to go through it at night. The matter comes at 10:30. And for what reason?
The information only in the morning, so
Sorry, if that is the case, either you argue the matter or you don't want it, then we'll give you a date.
Lordship, maybe posted on Thursday.
No, when the matter is called, we'll give you a date.
No one.
Please, Lordship.
Yes.
It's a transfer petition, Your Honor. The lady is from Medley, small town.
He lives at Surfacey.
Yes, Your Honor.
But the cases are at Siliguri.
But the case is at Siliguri, Your Honor. Since the marriage was solemnized in Siliguri, West Bengal, and Medley is just 55 kilometers away.
Already gone there, right?
Because it's a Section 9 petition, the respondent is willing to take back the wife. They never agreed to mediation on the first place, my lords.
Mediation, you're not.
No, sir. Earlier occasion.
Transfer.
Please, sir.
My lords, then kindly the respondent may be allowed to appear through VC.
Online, whenever it is possible. That line has to be added. As and when permitted. Just look at my corrected document. In that I've said as and when. If it is available in the transfer report and as and when permitted. So that option has to be. So, transfer, appear before the transfer report on 6th October.
6th of
October.
6th of October.
Deeply addressed.
So, who I am in the connection place.
The arguing counsel is online. Should be online, my lords.
Yes, made please, my lord.
Connected case.
Matter is right for hearing. Trial court records have been received. You've also been provided these records. Issues. Why do we need to take up your application for suspension of sentence at this stage?
Yes, my application for
They have been in prison for less than 2 years.
It's in 2 years.
yes.
Less than 2 years.
Case of acquittal, case of order of acquittal.
Maybe a reversing judgment, but you've suffered a conviction now.
Medical and oral evidence, they differ. Number one.
We'll hear the matter. Get ready with the main case. We'll take it up on a Wednesday.
As your
Leave seems to have been granted already.
the lead counsel.
Yes.
My lord
Leave
is
is
saying
already granted, so it can be taken up on a Wednesday.
next Wednesday.
Someone is appealing to DC Lord.
Whoever is appearing, will take it up for final hearings on Wednesday.
Yes, that's all right, my lord. Yes.
List for hearing on 24th September. Get
Yes.
ready.
After in compliance of last order, we have filed the injury report. And the
Head injury. She is unable to move her shoulder also.
those are basically
You don't know whether they would, this
this
lady
is
would
the-
be safe if you are granted any relief.
may I request, this is the basically OPD slip. What I have, this is the OPD slip, this is not the injury report. Kindly have lordship, this is the audit.
You have granted,
And this,
you have granted anticipatory bail on 24th of April and then you again assault her. This injury report is.
this is not the, this is, may I request? Actually, what happened, when we approached the Honorable High Court, we were granted interim protection, we went before the mediation, 2 times mediation proceeding conducted.
That failed now.
And in the first instance, it was conducted and it was agreed that we will be making 6 lakh rupees. Matter reached before the Honorable Court, it was apprised by the respondent that breakup of the payment is not mentioned. Again, we went before the mediation. In mediation, everything took place, Lordship.
Yes.
And
This even in this court minutes, the petitioner was granted interim relief on 1st of July 2024, before this honorable court. Even
First of July, right?
yes,
Interim from last 1 year, we are on interim protection.
that's the interim order.
And we
Yes.
have been directed,
Once,
sorry,
even subsequent there to minutes, in the trial court minutes, summons has been issued to him way back in 2022. We were just checking the internet last night minutes. He's not appearing.
It's not even appearing.
No minutes. I can play this minutes.
Lordship, we are actually the
File an affidavit.
revision petition.
I'm for R2 minutes.
But you
Your
got an
lordship,
affidavit now.
yes,
Why
your
didn't you say anything about this?
minutes, your lordships have directed me
Only
to
with regard to the
the payment.
payment. So you've received 5.5
Yes,
lakhs.
yes.
Yes, sir. We have been
That
directed.
clears the entire area.
Last 3 months is due because it was made in May. The payment was made in May.
So the revision petition was pending before
You're not
the
even appearing before the trial court.
Lordship, what I am requesting, matter was,
Why are you not appearing?
Lordship, I undertake
State
to appear.
government
Yes,
Apart from
is
that,
not appearing.
no, my lord, it's not appearing.
Lordship, apart from that, matter was pending before the Honorable High Court in revision petition.
So it is better if you're not cooperating. It's better that you're inside the prison.
Lordship, we are cooperating, even
You're
the,
not appearing. Both the learned council are saying so.
Lordship, even the settlement talk is going on before the Honorable High Court. That's why,
Either of you has filed an affidavit to that effect.
that's why we filed.
Please say so then. Give the details of the
You will file an
dates
affidavit.
on which it is not displayed. Learned council appearing for the state and also respondent to state that the petitioner has been appearing before the trial court despite the protection afforded to him by this court. We dare order dated 1/7/2020. We seek time to file affidavits stating this list on.
And also, this is not the FIR case, this is basically private complaint filed by the.
That doesn't mean that you don't cooperate.
Lordship, definitely, we are bound to.
25th September.
So like,
May it please, my lords. In this case, my lords, on the last date of hearing had permitted the petitioner to
Yes.
hand over a cell phone belonging to the deceased and some documents. Those were handed over, my lords, on the 16th and sent to the FSL. The FSL report has been received last night. I actually don't have a copy of it, although the police officers present in court with the report. So I'm requesting for some time to place it on the record, my lords.
Ms. Goyal, there's another thing. You have filed the CDR copy.
Yes, my lords. We filed a CDR copy, my lords, and I'm sorry I was not present. Please, my lords.
The date is 16th January and my copy at least is completely illegible.
If I may.
We have not been given copy. Just you have to last order, my lord, copy has not been given.
Learned friend may allow me. My lord, the CDR, if your lordship remembers, no normal calls were made, only WhatsApp calls were made. Which is why
this won't
help us.
No. Also in the CDR, my lords.
Phone of the deceased, then perhaps phone of the deceased has now been.
Yeah, it's been handed over, my lord.
No,
In any case, my
also.
lord, what I wanted to bring to my lord's notice, kindly have the states counter, my lord, just for a second. For the reason, my lord, that we have found from one of the orders passed by the Learned Sessions Court, the argument made by the Learned Counsel for Sumit, which is item number 4,
Yes.
was itself that he was there at the spot.
That is what his claim before us is. also.
Yes. My lord,
So, my lord,
before I-
He was definitely no question.
that is not the case, my lord.
My
In
lord,
addition,
if it be allowed, my lord, if
Please don't interrupt, Mr. Manoj.
Please.
We
Sorry.
can't hear who comes in
I'm
silence.
sorry.
You will have your turn.
I'm sorry.
if my lord remembers, my lord had requested for the CDR to ascertain whether they are there at the spot or not, because my learned friend on the other side had made this argument that we were not even there.
Yes.
Otherwise, my lord remembers there are 3 eyewitnesses to the case. Even if you say one of them, show if the nephew is an interested witness, and which in any case, my lord, the law is that interested witness testimony cannot be disregarded just because he's an
Anyhow, you have 2 independent witnesses.
Yes, my lord. There are 3 witnesses, my lord. Moreover, the co-accused, Vijay, who was the shooter, he had been caught. At his instance, the gun was recovered. Admittedly, Sumit and, Ankit and Vijay were in the same car. And all these people were called to the spot by Sumit, my lord. So, my lord, it's murder most foul. It's cold-blooded murder. And, my lord, may I also state again, my lord, at the pain of repetition, that these people had come and threatened the witness in court, for which an FIR is lodged and pending. And my lord, he has a criminal antecedent. which he did not disclose to the High Court.
Ms. Goel, what is the FSL report now in relation to the phone of the deceased?
My lords, yes, my lords, 2 points. My lords, may only allow me to submit 2 things, my lords. One,
Yes.
yes, absolutely, my lords. We received or rather the police received the deceased's phone, and the FSL report is in regards to verification of that. But our filing was not particularly clear, my lords, I will admit. But the call data records actually show that the accused Sumit called the deceased multiple times at the relevant time, and I can point out those lines for my lords.
The records that you have filed.
Yes, my lords.
The difficulty is my copy at least is not there.
My lords may give me some time to file better copy, but otherwise on page 3, it
And now
shows
you
that
have to verify whether these calls were made through WhatsApp. If it's a WhatsApp call, it won't be registered in your regular call data.
these are actually regular calls, the ones that come in the call
You also
data.
have to verify the WhatsApp on the deceased phone to see what calls he received through WhatsApp.
I
That
think
would
that
be
is what the FSL report was
WhatsApp
likely to. We will verify, my lords.
itself. So that you will have to indicate as to whether you found anything there.
Subject to technology permitting, I must say, because I'm not.
You don't use WhatsApp then, Ms. Goel. WhatsApp would have, there's a separate icon there which shows the WhatsApp calls.
Yes.
Please, my lords. Please, my lords.
You can take a screenshot of that and file a copy of these
Please.
WhatsApp calls that the deceased got on his phone.
Please, my lords.
My Lord, may I just request for as short a date as possible, my Lord. I fear for my life, my Lord. I'm being threatened again and again when I go to the court.
Ms. Goel, this threat of injury to the brother,
Please, my lords.
that something needs to be done because you already mentioned it in your counter that there was a FIR
No.
registered also.
No doubt, my lords.
My lord, to permit me to say
That is there, my lords.
last 4 days.
You've already registered a FIR. Please see that adequate protection is given to this man in case there is any threat.
My lord,
Him or the
We
family.
will abide by my lord's
we
directions.
have
Absolutely, my
that
lords.
the last 4 days he is not appearing. Bailable warrant has been issued.
He's not appearing because he's scared of you.
That is not correct, my lord. We are not.
Threatened him in court. That is the allegation.
Yes, my lord. He is very powerful man.
Allegation is that you threatened him in court.
My lord, he is one of the powerful men in the area, my lord.
We
And
find that he's not of
he-
more powerful.
My lord, your lordship may just see his conduct. Trial court has issuing bailable warrant and he is not.
Let Mr. come forward with the report.
Your
I was so powerful. I would not be in this.
Your lordship may call the report.
My lords may give me at least 2 weeks, my lords.
States that the mobile phone of the deceased was handed over only on 16th, you said,
Handed over on the 16th, my lords.
of this month.
Of this month, 16th August, we have a receipt in writing, and 19th we sent it to the FSL.
And was subjected to examination by the forensic science laboratory. She seeks some time to place a copy of the report in that regard. An affidavit shall also be filed giving the details of the WhatsApp calls received by the deceased, which would be available on the phone or mobile phone of the deceased. Steps shall also be taken by the police to ensure the safety of the complainant as well as his family members, if there is any threat to them.
So copy should be given to us, my lord.
Sorry, you also want protection, is it?
No, copy, my lord.
Copy of-
Every day your lordship pass order. You not lie at all.
Copies to the other side, Ms. Goel.
We have served copies, my lords. I have
Yes,
emailed
sir,
it,
my
filed.
lord.
The registry would not
Why shall
accept
we
the
complain
filing.
with such my
Copies
lordship?
of the
We will again serve it, my lords. We will again serve it.
report
Legible copy, yeah.
that would be filed by the next day shall be furnished to the land council, preparing for the parties.
Highly obliged.
Highly obliged.
How much time would you require, Ms. Goel?
2 weeks, my lords. May give me at least 2 weeks, my lords.
16th September.
I'm so grateful.
Grateful, my lords.
Yes, I was protected by this honorable court and I've joined the investigation in this matter. This is a dowry death case. I am mother-in-law.
Now, counter affidavit is filed by R2.
R2, they filed.
Charge sheet has been filed.
I am appearing for R1, right? We filed.
You filed a counter.
Charge sheet has been filed in this matter.
is filed yesterday itself.
What have you said, states counter? Let us see.
Lords, even the call records, call details also has been found below the place and the time has been. At the same time, they are at the incident presence of the accused persons that is mentioned below. And
No, but
it's a corroborative evidence.
supposed to have committed suicide.
Yes, see, that's suicide because of the continuous harassment of the dowry.
But the mother-in-law was present at the spot.
Yes, that's what indicating the call records details.
And the poison packet or whatever.
Yes, that's and evidence also destroyed. Some part of evidence also they have destroyed.
Postmortem report confirms that it was
Yes,
poisonous.
poisonous. That is because of the cause of the poisonous that thing.
And only the husband is inside.
Not only the husband is inside. The rest of the other accused has been granted bails. Anticipatory only.
How old is this lady?
52, my lords.
It was not very old.
My lords, I understand. My lords, but the allegations leveled by the investigation.
Look at the amount of tampering that has gone on.
No, my, that has not been done. My, that is there.
Where did the poison packet go?
My lords, even the father-in-law took her to the hospital.
She took the poison and safely
No,
away the poison packet and then died.
No, my lords, nobody was aware that how she took the base.
Where did the poison go?
I don't know, my lords, but
Who were the persons at home?
my lords,
When she consumed the poison,
father-in-law.
what kind of poison was it? Instantaneous death or it took some time?
Fast, my lords, that rat poison. We reported to the hospital. Father-in-law took her to the hospital. We took all the measures.
That is the whole difficulty. You took all the measures possible. Secret away everything.
My lords, kindly see, I was
taken care of.
I was not even the resident of Gwalior.
Postmortem report unfortunately spilled the beans.
No, my lords, kindly, what has happened, my lord, she was living in Ahmedabad separately with her husband.
Your call data
Well,
record places.
I can explain everything, every query put by this officer.
Your phone is there without you.
The phone was there, my lord, I was
But
there.
you were not.
I was there for my son's marriage.
Then you left your phone behind and went away to some other.
No, my lord. I live in Agra. I came to Gwalior. Everybody gathered, the whole family gathered there. And my lord, after she used to live separately in Ahmedabad, my lord, with her husband. My husband was working in Gwalior, Ahmedabad, my lords. The rent agreement is there on the court, and she was suffering from some gynecological problem. She was not conceiving. She was disturbed by that, my lords. And that is the document which I have also annexed with my paper book. Everything is there, my lords. The mother-in-law used to live in Agra with father-in-law. After granting of this interim bail, and see the allegations, my lord, all of them have jointly asked for rupees 10 lakhs. And everybody has been given anticipatory bail, my lords.
Only the sister has been granted.
No, my lord, father-in-law has been granted bail after the interim bail granted by this honorable court. The magistrate, the High Court has granted anticipatory bail to the father-in-law.
Well, you would be more responsible.
I don't know
the one instigating the son.
See the allegations, my lord. Only allegations will speak, my lord. See, there is not a specific allegation against
what
me.
have you said in your counter article?
Kindly see, my lord.
Please, Judge.
Yes.
Kindly see the allegations, my lord, in the FIR.
Let us hear what articles counsel has to say.
Judge, the main thing is, my lords, that in the charge sheet, this has come that they have caused disappearance of evidence. Now,
Yes.
that part is also corroborated by the fact that the mobile phone of the deceased was also kept by the accused persons. And that has been seized after 6 months of the incident.
I see.
And my lords, one more part is that there are WhatsApp conversations which I have annexed, although we could have only few conversations which were available with us right now. So I have annexed those where she has clearly given apprehension that she will be murdered someday, and she was beaten badly by the husband, though the allegations were against the husband that he was beating. And then subsequently, my lords, the phone which was the primary evidence in this case where these conversations were there, that has been done away with, the data has been done away with, and that then it has been handed over to the investigating officer after 6 months. And insofar as, my lords, the residence part is concerned, they have annexed the Aadhaar card to show that they are residing at Agra, whereas that Aadhaar card, when we have verified on the Aadhaar portal, it shows Gwalior. In fact, they have gone to the extent that they have prepared affidavits of 2 persons, which were also part of the charge sheet, where they say that those 2 persons sworn on an affidavit that these persons were living in Agra and they were not living here. And subsequently, those 2 persons gave section 161 statement before the investigating officer. And they have said that those affidavits were got prepared by the accused persons. So they are trying to temper every evidence available, my lords.
They are not in the prosecution.
My lords, in my counter, my lords, we have annexed that autopsy report, my lord. That page 20, it has been there, my lord. Actually, that crime scene was deliberately tampered with removal of the poison packet and other material, my lord. The autopsy report is at page 20. It is annexed R1 to my counter, my lord. The opinion starts at page 20, my lord. Opinion of the hospital assistant surgeon regarding the cause of death and its type, suicide or murder. Opinion, cause of death of this case is kept pending. However, stomach, intestine with its content, pieces of liver with gallbladders, spleen and kidneys are preserved for chemical analysis. Final opinion, the cause of death will be given receipt of this one, my lords. Actually, that last para, however, finding in the postmortem examination are consistent with poisoning. That bottom line of the page 20 and page 21.
My lords, may kindly appreciate the marriage took place on 8th of July 2022. She went to Ahmedabad along with the husband on November 2023. By that time, she lived there. Rent agreement is there annexed herein with.
She died on 27/12/24.
Yes, Your Honor.
Just about 2 years later.
Yes, my lords. Now, what happened?
And her WhatsApp messages to her family clearly.
That was in 2023. My lords, that was, kindly have that, my lords. I can read it. That is not against me.
And the biggest factor that weighs against you is this tampering with the.
No, my lord, I have not done it, my lords. Kindly appreciate, my lords.
Poison is removed. The
mobile
phone is removed.
My lords, she was there. Rat poison is not easily
this,
available.
Phone of the deceased which has been recovered. Did you find any tampering with the content?
No, plus that is FSL report.
It is not there, my lord.
Still awaited.
It is not there. I can give an undertaking. I have not tempered anything, my lord.
You can give an undertaking after the event.
My lord, kindly appreciate. My lord, kindly let me. I might have a case, my lord. Allow me 2 minutes. I can show everything that they are saying.
Please tell us one thing. Were you present there or were you not?
I was present there. Father-in-law was present there. There was a marriage. My lord,
what happened to the poison packet or bottle or whatever it is?
My lord, rat poison is not easily. See, these sulfaz is not easily available in the market.
Couldn't have had it in her palm and then taken it.
My lord, kindly
must have had a container.
My lord,
what happened to that container unless one of you removed it?
My lord, I can explain that. In the rural areas nowadays, this sulfaz, this rat poison, is not easily available because of the suicide turns very fast.
Okay, so where is the container?
He brought it, my lords.
Where is the container is what we asked.
My lord, it is not that she would have taken it as a tablet and just got it. No. Container would have been, my lords, with her knowledge.
Is it a liquid or is it a?
It's a tablet, my lord.
Tablet type.
It's a tablet.
It's a tablet, my lord. Tablet could have been taken by her.
But Miller's that deliberately tampered by removal of these
My lord,
pockets
she
and
was-
other material, Miller's.
What other material?
That other material I have to find.
My lord, there
We
is
have
nothing.
mentioned in my counter affidavit at page 4, Millard, para 8. Para 8. So para 8, middle, Millard, the mobile communication between husband Sachin Sharma and the deceased on the night.
What do you mean by other material? You need to.
Other material.
This cell phone perhaps. Cell phone of the deceased was removed. What else was there?
Millards, that's only Millards. It's mentioned only the limited other material it has been mentioned.
My lords, kindly have the counter for a moment. My lords,
As per my instructions.
my lords, kindly give me 2 minutes. I have not
amount of time
My lords, at least my appetite of argument. Give me 2
on
minutes.
how you treated another woman.
Give me 30 seconds, my lord. I can explain. Still, I have not, my lord, I have not still completed. Give me 30 seconds.
Yes.
I might.
30 seconds. Your clock starts now.
My lords, their document of postmortem shows that uterus was small. It is there at page 24 of their counter. My case is that she was disturbed because of some gynecological problem because she was not. It is there, my lords. I have annexed the documents. Kindly see the document, my lords.
Very good. That's one aspect then.
The second aspect is, my lord, she was living in Ahmedabad. I was living in Gwalior with my father, with my husband. And husband, me and other persons as per the allegations are on similar footing. Kindly have the allegations for a moment, my lords. See the allegations. They say rupees 10 lakhs was jointly demanded by everybody. And my lords, I have annexed my the bank proof of this lady. Rupees 3,12,000 was given by me to her every time, and she has given the money to her in-laws. How can she be deprived of financial
She
things?
is giving money to her in-laws.
In-laws, my sorry,
In-laws would be-
my in-laws, my lords, my in-laws. Their relatives, the relatives of the deceased.
Where is the proof of this?
My lords, I am saying, see, funds transferred. It is annexure P8, my lords.
Page.
Page 55 of my petition, my lords. This was given by deceased to her brother Gaurav, 25,494.
Where is the proof of you transferring money to your daughter?
That I am showing. Husband gave to her wife, my lord. She was not deprived of anything.
You said that you transferred 3 lakhs or something to her account.
Me means my husband,
Where
my son.
Why make these
I'm
loose
sorry, my lord.
statements and then when
I'm
we
sorry,
pin
my-
you down to it, then you try to.
I'm sorry, my lord. My son
He's out of it.
My son gave
Wiggle out of it.
My son gave it.
That is not what you said earlier.
No, my lord.
This kind of advocacy
I'm
we do
sorry.
not like.
I'm sorry, my lord.
Here it's a regular feature. So you have to be mindful of. You make a loose statement, pin them down to it, then it will be true. It will be shown to be completely incorrect. So be very careful not to be trusted. Learned counsel in the Supreme Court are not to be trusted. Everything has to be shown.
My lord, I'm showing it, my lord.
You have proved that
No, my lord. I'm
advice
sorry.
given to me by one of the senior judges.
It was
I sat with.
It was unintentional. It was unintentional.
Not you alone. There have been several others who preceded you.
It was.
But you are also true to time.
I'm sorry. I'm sorry.
Sorry,
It was
counsel.
unintentional. Kindly have the
That
document.
sealed your fate.
My lord, kindly see
This
the
kind of loose
My lord,
statements being made in
I
court,
have.
it is better that you change this
My
kind
lord,
of tactic which you use.
It is not a tactic, my lords.
Obviously.
It is not a tactic, my lords. I'm sorry, my lords. It is not a tactic, but I am relying on a document. It could be a slip of tongue, my lords. I'm sorry, but the client should not suffer for that, my lords.
Sorry, we have also seen the record discussing here.
Kindly see this document, my lords. The husband has given 3,12,000.
Leave granted. No, why should we grant it?
Yes, this also.
Heard learned counsel for the parties.
My lords, I have also given the bail bond before.
Sorry, your case is over now. So, as per the arguments made in the counter affidavit filed by the state,
My lord, I am again sorry, my lord, kindly, he should not suffer, my lord.
The counter affidavit filed by the complainant of the respondent number 2. We find that sufficient grounds are made out to infer that the scene of the offense where the body of the deceased was found was tampered with. The call data records placed
Can I withdraw it? My lord,
at the scene of the offense. And the WhatsApp conversations placed on record, copies of the WhatsApp conversations placed on record, by no case ensure that the petitioner was subjected to cruelty. Even these.
my lord, they have created certain documents just to support them, my lord, there are certain other things to be argued.
The interim protection granted by this court, the 5/6/2025 shall stand vacated. The special petition is dismissed.
I'm sorry, my lord, I'm extremely sorry, I'm forwarding my apology, but that was a slip of tongue, my lord, out of the curiosity of the argument.
The tongue is not for.
My lord,
You're an advocate before the Supreme Court.
It has happened.
Every sentence that crosses your lips, you must
I will take.
Think about it and then state it.
My lord,
don't say something that is convenient for
I
that
was under the
moment,
pressure that
knowing fully well that you will not be able to support it. Just to get away with that sentence at that moment, maybe we'll just swallow it, hook, line and sinker, and don't ask.
I was under the pressure of 30 seconds, my lord.
Sorry.
That 30 seconds pressure has done it.
Sorry.
And I'm sorry, my
lord. Next matter.
Your lordship, as per the last order, I have.
You filed the.
Yes.
There's no bar insofar as.
No bar. That is external page number 403. Your lordship, the
page?
External page number 403 is the policy. As well as the order of the trial. External page number 403.
403.
Yes, yes.
403 is not that.
Chapter 40.
Yes, that's pre-release.
Yes.
There's one other. You would come under this review of sentences, is it?
397 page.
397.
Yes,
review of sentence. Life convicts. And then review shall not be permitted. They have given the cases which are not to be reviewed. That is that. (54.1). So you don't fall under this.
No, I fall under this.
No, excluded categories you don't fall under.
Yes.
Only rape, forgery, dacoity, terrorist crimes, corruption, black marketing, 489 counterfeiting. Will not be anything. Notice has not been ordered.
And the trial court order has also been filed, your lordship.
Issue notice. Then note.
Your lordship
shall be effective by all modes.
Notice also on bail, your lordship. because 15 years, 6 months in.
We have to see what their policy is. In case your case can be considered, why should we grant you bail at this stage?
During the.
You would have to go under that. The SLP has already been dismissed against your conviction.
No, Lordship, he has not filed SLP.
He has.
He has not filed SLP.
SLP was dismissed on 25th February 2002. Against his conviction.
No, Lordship.
The death sentence was reduced to life imprisonment by the High Court.
No, Lordship, actually is some confusion, Your Lordship, due to the typographical error and careless in drafting of the petition. Such thing has come in. Your Lordship, to kindly see the trial court order. He was convicted in 2012, Your Lordship.
2012?
Yes, Your Lordship.
What is this note then?
Different. Page 723, Your Lordship.
Page
723. External designation 723.
You must have filed it in the SLP itself.
Your Lordship, on the last date of hearing, Your Lordship had directed to file that order. 6th of January 2012, he was sent.
Did you file a copy of the judgment of conviction here?
Yes, Your Lordship. External page number 723.
No, in the main SLP papers.
No.
You only file copies of the
Yes, Your Lordship.
orders passed by this.
In the main SLP it is.
723. Then in your SLP synopsis, you've given wrong details. Yes. Paras.
Yes, Your Lordship.
Wrong details
On
in
the last
synopsis. That is why we are going by this.
Your Lordship, on the last date, I apology for that, Your Lordship.
Details in this.
I am extremely sorry for it. It was wrongly drafted. Your
We
Lordship.
have to hold our heads in despair, if not worse. Are you aware of Justice Abayok's judgment about AORs and the responsibility that rests on them?
Yes, yes, Lordship.
What is it that we can do if this is the level of responsibility that is?
Extremely sorry. I bow down, Your Lordship.
There is a question of saying sorry.
Your Lordship, casually
This is another get by the moment apology. Just say sorry, get on with it. Next matter again, some clerk or someone will do the drafting and you just file it.
That will never happen in future.
Less said the better. We have to hold our heads in shame, not just despair. This is the standard in the highest court of the country, unfortunately. But let me tell you, all the high courts that I have worked in, far higher standards, far higher standards. Even Manipur, such a small court, 3,000 and odd pendency, presently now 5,000 or 6,000, whatever it has gone up to after COVID, far higher standards, both in pleadings as well as arguments.
I vote on the Lordship.
It is truly unfortunate that we have to put up with this kind of substandard level of pleadings as well as advocacy. Not one thing can we trust, either written or spoken. And this is the signal you're sending out to my brother. Just come here. What do we do?
I apologize, Your Lordship.
File an amended.
I will file it.
Counsel for the petition. We are not issuing notice on this wrong affidavit, wrong synopsis. And counsel for the petitioner seeks time to file an amended copy of the petition along with an amended copy of the synopsis giving proper details of the petitioner's case based on 10th November.
7.
My lord, I have.
Respondents 2 and 3 after. We need to file a
Filed a response. We filed a response not placed on
You
record.
filed a count.
Lord, just 4 reasons why the bail should be cancelled. According, they had filed 7 applications, 7 times it is rejected as part of the order. On the 8th occasion, when they accept the bail, the 7th occasion the bail is granted, it's without reasons. I'm going by my lord's order.
Impugned order.
Yes, without reasons, and the earlier orders are giving copious reasons. We put the compilation of all the orders of.
Order compiled?
Yes, we put it on record.
IA number 169.
IA number 169,566.
For the first petitioner, they were withdrawn. For the second petitioner, there was one order.
When did you file it?
30th of July. Lord, this is 169566.
You don't have that IA at all. There's one IA without a number, perhaps.
What is it?
What is the date?
Is it 21st July?
21st July.
Yes.
21st.
But Your Lordship may look at the orders from page 6 onward.
And the last point is, my lord will just see page 110.
Let my
How
lord.
the head was blasted by repeated firing.
110.
Fair statement of
Statement of the forensic.
110 is
3C6, Annexure P15, para 2.1.
PW11's deposition.
Yes. I inspected the crime scene with TI Rajoria.
Yes.
At the crime scene, the deceased was lying upside down on the front seat of the Scorpio number so and so. On the other side of the driver's seat, the entire head of the deceased was broken, with which blood and flesh was seen on the ground and on the vehicle. Repeated firing, all on the upper side, blasted the head. And that is why for 6 times the bail was rejected. That is what the court notes. And on the 7th occasion, my lord, we just see, if it's a speaking order, I will not say anything. And that is the judgment of my lord, which I'm placing in record, paras 30 to 33. To 2023, 6, 120.
What's the citation, sir?
Which page?
Name.
So the citation is.
You wanted to show us the earlier orders?
Yes.
So the earlier orders might not be seen. Says my friend is saying their orders on merits. Let's see that. What page 6 on page 6 of that IA.
That's a withdrawal order.
All withdrawal. First petitioner only withdrawal. Second petitioner one order on merits accepted, but first petitioner only withdrawal. So it's not fair to say that there were orders on merits.
When it's getting dismissed, you withdraw.
I'm sorry, sir. You made a statement that it was. My learned seniors made a statement. There's an order on merits. It's not so.
Order is page 26 to 524, and then they kept on repeating.
Whose order is that?
This is first see the page 26 order.
26.
It may be the other court, but look at that order.
Yes.
Because one is father and a son. As per the prosecution story dated 15/12/2008,
Last para page 26, my lord.
Dashrath Singh made a written complaint to Police Station University Gwalior alleging that on 15/12/2008 at about 5:30 in the evening, he along with his brother Ram Khilari were going on a Scorpio vehicle to office of one Ram Nivas Sharma, which is situated at the University Road. They were being followed by their companion, another gypsy vehicle. When they were reached in front of Ram Nivas Sharma, Lakan Singh, who were already standing there, fired a gunshot at the head of his brother, due to which his brother Ram fell down. Thereafter, other companions Ram Charan, Betu, Viren Sharma, present appellant Omkar Sharma, Man Singh, Lalla, Banti Gujar, and one Dina started firing indiscriminately and abusing in filthy language. It was further alleged that Ram Charan Sharma, Omkar Sharma.
One moment. Yes. Continue.
It was further alleged that Ramcharan Sharma, Omkar threatened to kill him. Complainant Dashrath PW5 saw the entire episode of the incident, but he barely escaped himself. The above miscreants were also fired on those persons who were sitting in the vehicle gypsy, namely Balram Singh, Kailash Singh, Gandharv Singh, and Damodar Singh. It is further alleged that the role behind the entire incident was made by Rakesh Shukla, MLA Mehergaon, Ram Nivas Sharma, and Suresh Gujar. On the basis of the above citizen complaint, FIR was registered. During investigation, spot map was prepared, statement of witnesses recorded, Safi form and large Panchnama prepared. All accused persons were arrested and relevant seizures were made. Upon completion of investigation and necessary formalities, Charan was filed before the competent court, the learned trial court on appreciation evidence placed on record, convicted and sentenced the present appellant as referred above. Then it counsel for the appellant while taking exception to the influence judgment of conviction and order of sentence submit that Dashrath PW5 and Balram did not support the prosecution version. Dashrath PW5, who's an eyewitness to this, had come after the incident, therefore his evidence is not reliable. It is further submitted that no incriminating material is available on record against the appellant. There is no recovery at the instance of the present appellant, as well as no specific allegation of causing gunshot fire at that disease is attributed against the appellant. There is no direct or indirect involvement of the present appellant. It is further submitted that learned trial court has not appreciated the entire evidence on record in correct perspective. An impugned judgment suffers from surmises and conjectures. The present appellant has falsely been implicated. It is also submitted that there are material contradictions and omissions in the statements of prosecution witnesses. Learned counsel has committed an error in convicting, trial court has committed an error in convicting and sentencing the present appellant. It is further submitted that the present appellant was on bail during trial and did not pursue the liberty so granted. Appeal being of 2019 is not likely to be decided in future. He is ready to abide by all the terms and conditions which may be imposed. On the basis of the above ground, it was prayed that the present appellant may be extended the benefit of suspension of sentence and grant of bail. Per contra, then it was the public prosecutor appearing on behalf of the respondent state while supporting the judgment impugned submits that no exception can be taken in the matter of suspension of sentence and grant of bail regard being had to the nature and gravity of offence found proved against appellant, as well as the fact that there was active participation of his office in commission of alleged offence. Therefore, the appellant is not entitled to be released on bail. On those grounds, is paid for dismissal of application. Upon hearing the counsel for the parties through this court, it reaffirms from commenting upon rival contentions so advanced touching merits of the case, regard being had to the fact there is active participation of present appellant in commission of alleged offence, as well as the nature and gravity of the offence in obtaining facts and circumstances. We are of the view that the present appellant is not entitled to the benefit of suspension of sentence and grant of bail, i.e. it stands rejected. This is on 2/5/25. This is and Varinder. Then please see the next order, one before.
This is after that also. Let us see what Mr.
And another order at page 30.
State Council also aspired account.
Yes, but state is so just one judgment, sir. That's all. This is a recent judgment of 2023, volume 6, 123, paras 30 onward. This is on how to grant bail in 389.
2023.
Volume 6, SAC 123. Para 30 onwards. 30, 31, 32. I'll just read the note. This court has indicated the factors that require to be considered by courts while granting benefit under 389 CRPC in cases involving serious offences like murder. Thus, it is useful to refer to the observations made therein, which are as follows. And then the court has quoted other cases of the Supreme Court. And that in para 32, 33 it says, bearing in mind the aforesaid principles of law, the endeavor on the part of the court, therefore, should be to see as to whether the case presented by the prosecution and accepted by the trial court can be said to be a case in which ultimately convict stands for the fair chance of acquittal. If the answer to the above question is to be in the affirmative as a necessary corollary, we shall have to say that if ultimately the convict appears to be entitled to have an acquittal at the hands of the court, he should not be kept behind bars for a pretty long time till the conclusion of appeal, which usually takes a very long time for decision disposal. However, while undertaking exercise to entertain whether the convict has fair chance of acquittal, what is to be looked into is something palpable. To put it in other words, something which is very apparent
or gross on the face of the record, on the basis of which the court can arrive at a prima facie satisfaction that the conviction may not be sustainable. The appellate court should not reappreciate the evidence at the stage of 389 CRPC and pick up a few lacuna or loopholes here or there in the case of prosecution. Would not be a correct approach. In the case on hand, when the High Court, what the High Court is something impermissible. The High Court has gone into the issue like political rivalry, delay in lodging FIR, some overwriting in the first information report. All these aspects will have to be looked into at the time of final hearing of the appeals filed by the appellant. Upon cursory scanning of the evidence on record, we are unable to agree with the contentions coming from the learned senior counsel for the convicts. Either there is absolutely no case against convicts, or that evidence against them is so weak and feeble in nature that ultimately all probabilities of the proceeding would terminate. For the same reason, we are unable to accept the contention coming from the convicts through the learned senior counsel that it would be meaningless, improper and unjust to keep them behind bars for a pretty long time till they are found not guilty of the charges. In overall view of the matter, we are convinced that the High Court committed a serious error in suspending the substantive order of sentence of convicts and the release on bail pending final disposal. In fact, it was expected of the state as the prosecuting agency to challenge the order. And in the quoted cases, the Supreme Court says you must record reasons, especially in matters.
Yes.
State Counsel. We are supporting petitioner in this case.
Yeah.
And the primarily contention to Honorable High Court, especially in relation to the delay in FIR.
3 hours.
And the other
3 hours delay.
3 hours. Your Lordship, the Honorable Trial Court has sufficiently answered that question that there is not a substantial delay in the given circumstances, Your Lordship. And similarly, the other findings in relation to the merits of the case in suspension of sentence application is not justifiable, Your Lordship. So that is our primary contention that on merits, High Court should not have made any findings in this order, Your Lordship.
Yes,
that's why it's not justified, Your Lordship.
Yes, my lord, let me just first begin.
3 hours delay to begin with.
No, I'll give you the answer.
Not a delay at all.
All right, Lord. The answer to that will lie at page 125. Let's look at it. I'll tell you, Lord, why. And please come to Lord PW 14, whose testimony is, he's the IU, very important, Lord. Just give me.
And you've noted what the
121
judgment says. At the stage of 389, this kind of reappreciation of the evidence.
The
order here practically decides the appeal.
Lord, may I just say this?
Yes.
May I just
this
say
order now, please look at the observations made by the division bench.
Lord, if on a
story appears to be improbable, such delay prima facie smacks of false implication. He's decided the appeal practically.
May I just say this? My learned friend's grievance, by the way, in the SLP is something different. The SLP, please see the ground. The ground is not
in the grounds.
My lord, allow me a moment.
Allow
me a moment.
This kind of observations.
My lord,
at a 389 stage.
My lord, may I just take 2 minutes? Lord, I understand this. No, Lord, let's be very clear. Lord, and I must tell your lordship conceptually. We have a challenge here. A court at the appellate stage has to, while granting bail, having declined to grant bail earlier, has to give some level of reasons. The reasons may be more. I accept that point. But if the reasons fall short, then the challenge is that there are no reasons, which is their case. The lordship's view is the reasons should not have been given. I accept. I appreciate. That's a valid perspective.
It also need to be couched in proper terms. Like this.
It's a foreign language. Now, it is a foreign language. Not, I often say, not we people speak. Speaking myself. Not now. Allow me 2 minutes.
By the time they come to the division bench, they should have at least a sufficient grip on the language not to make these kind of gaps.
My lord, I must tell your lordship, the kind of gaps that are being made today, it is, and your lordship, I've been observing the proceedings since the morning. We are all sinners at some level or the other, and the gaps that are being made are actually quite completely unforgivable. It's a matter of fact. Not just yesterday, I've dealt with a matter where the stand is taken contrary to the record, and I had to pull my hair out and say, you've taken a stand contrary to the record. What's the purpose? We had to go to the court and cut the sorry figure and say, look, we filed this in the trial court, we filed this in the high court, now we want to clarify it because the document speaks something else, which is actually in our favor, but we anyway. Lord, now I tell your lordship what the issues, just for a moment, keep 2 things in mind.
and I'll be very clear with you. The High Court has not, in fact, wrongly noted even my period of custody. One person is about 8 years.
5 years. 5 years?
Not 5 years and 8 years.
One is 5 years, one is 2 years.
Not 5 years, no, that's wrong. I'll just show a lot. Not it's wrongly noted. It's wrong. Just see Lord for a moment.
You have the custody certificate?
Yes, Lord. Please come to my reply. Please come to my reply.
Yes.
Lord, page R2 is page 32. For Onkar Sharma, 70-year-old gentleman, the father. Please come to page 33. This is as on August, 2nd August, yes. Kindly note, it was 4 years, 2 months, and 5 years, 9 months is with remission. My Lord has page 33. Yes. Then my Lord, please come.
Which date though?
Lord, 2nd of August.
2nd.
Lord, so it's the most recent certificate because he was out. Now, Lord, please come to page number 35 and please see at page 36. For the son, it is 5 years, 9 months, and with remission 8 years, 2 months. So that is an error. Lord, I must.
We will not take into consideration the remission period.
Yes, Lord, 5, Lord, so 4 years and 5 years.
Both of them less than 5 years.
Yes.
Or around 5
No, Lord, one is got 5 years, not less than 5.
Little over 5 years.
Yes, because the father was on medical bail for a while. Then after he surrendered, it ended, he went back to custody, matter was over. Now, Lord, my learned friend began with a prejudice argument to say that 7 bails have been dismissed. Now, please see those orders. They were withdrawals, accepted, not a dispute. Please come to his application, P1 at page 6. And my learned friend has not pointed out to your Lordship where the distinction is. There are 2 bail orders which are under challenge in the same SLP. For the father, 70-year-old gentleman, it is the first bail order on merits, no merits order before. The son gets it on parity. It's not a question of merits. So the argument was flawed.
Sorry?
My Lord, there are 2 bail orders under challenge. The father and the son.
Not the same order?
No, Lord, not the same order. The son got it on parity. The father got it on merits. Son gets it on parity. I'm going to show your Lordship. That should have been shown to your Lordship in all fairness. Now, please see, Lord, page 6 for a moment, withdrawal. And please see the date of withdrawal, 2019. Then, my Lord, page 6.
Yes.
Page 6, Lord, this is 2019 withdrawal.
Yes.
Page 7, my Lord, we'll see parole sought. It is sent to the appropriate bench, Lord, for consideration of parole. Page 8, he seeks liberty to withdraw. 3rd repeat application, no problem, 22. Then, my Lord, page 9, withdrawn, again in 22 for whatever reason, Lord. Page 10.
Only one reason. It's withdrawn because the court is not willing to.
I'm not disputing that.
This is what happens here.
I'm not disputing that, Lord.
Obviously, after arguing and you're not meeting with a positive response.
I'm not disagreeing with your Lordship.
They withdraw it.
I'm just I accept. The only thing is I'm pointing out only a specific thing. An argument is made before your Lordships today that there were merits dismissals. That is not the case. So let's not go by that. Page 10. Page 10, please note, Lord. He was not given interim bail at this point. Please note, last but one para, under such circumstances, we find no reason to suspend temporarily on medical ground. We consider appropriate to direct appellant shall be given proper treatment because he had certain medical illness. And now, my Lord, please come to page number 12. Last but one para, as per medical health status report received from the office of so-and-so, suffers from heart ailment for which specialized treatment is, therefore he's been released on parole. And then, my Lord, please come to page number 13, 3rd para. It is directed that the jail sentence of appellant Onkar shall remain suspended for 4 weeks. So he gets interim. It's not that it was dismissed. My learned friend keeps saying it was dismissed. Let's see further.
Because of his health condition.
Yes, of course, Lord. No dispute at all. Lord, then it's continued at page 15, Lord. And finally, my Lord, it is again continued on 25th July. And Lord, on 30th of July, which your Lordship will find at page 21, he is asked to surrender.
Okay.
So that was a surrender on an interim bail, not on merits. Now, please come to the orders for a moment in this case. And I will begin by the first one. The SLP page 2 now for a moment.
Yes.
At page 2, it captures my argument. And please come to the argument. This is an argument at page 3.
Yes.
Please note page 2 bottom. It is my argument. I'm sorry. It is my argument at page 2 bottom, which is encapsulated, not the Honorable Court's finding at this point. Lordship got it. It is the submission of learned counsel for the appellant. The trial court heard in convicting and awarding the jail sentence to the appellant. Further submitted cases of doubtful origin, false implication, which is reflected from the fact that incident at 6:30 has been registered in the instance of brother, namely Dashrath PW5. Murg intimation has been given at 9:30. Even the story that Dashrath and deceased were going and in the Scorpio, then the appellant and other co-accused aimed and opened fire. Said story appears to be improbable because if this incident happened, the brother of the deceased would have lodged an FIR or complaint instantaneously. Such delay premisi smacks false implication. Even otherwise, role is of so. So this is my argument. Then comes the state one-line argument. Oppose the bare basis.
This makes it worse.
I know.
Because the next order adopts your submission word by word and makes it the
I'll come to the next one. I'll come to the next order.
What is the level of application of mind by the division bench?
My lord.
They take your submission word by word as reproduced in this order and then make it their own reasoning in the next order. Word by word.
Can I just but you've not seen the second order. Let's see the second order together, Lord. Let's see the second order together. Lord, what was told to your lordship, the impression, I'm sorry, with respect to the impression given to your lordship was that this is a finding of the court. It is not a finding of the court.
The next order.
And your lordship took a view against me that it's a finding of the court. Not that.
This is the next order which makes this the reasoning, the finding of the court, as you put it.
My lord, your lordship said it is the finding. I just corrected it, Lord. I just wanted to correct that position. Please come to page, Lord, this should be number 7. Now, Lord, here the argument is made till page number 8 bottom. And I want your lordship
produced as your submission.
No, Lord, it's all of this is my submission. Argument is made. Now, please see the argument here was distinct. After all of that, he suffered. Come to page 8, first para, 8th line from the top. I'll just, even otherwise, role of appellant is of omnibus because Dashrath PW, according to Dashrath PW5, Lakhan who opened fire, he suffered 5 years, 2 months incarceration, pre and post trial detention. Hearing of appeal would take time. The appellant claims parity with co-convict who has been granted benefit of suspension by this court on 13 December. So this is only parity. This is primarily parity, and the order then goes on to grant bail. So it's on a parity issue. It's not that I'm re-arguing the merits. Now I'm not come further. I want your lordship to see.
Which year's appeals are being taken up by the MP High Court? Present.
Not 14, 15, I'm told. 14, 15, Lord. And I just want your lordship to see one more thing, Lord.
Is that a fact? You verified?
It's a matter of fact. Not one more thing I want your lordship to see. So far as this issue of Dashrath on merits, I can show to your lordship, and I've not done some analysis.
One moment.
Now, Lord, please see. in this case, just see what PW 14 said.
One thing though, if you look at both the orders, actually I stand corrected. Even in the second order that is not adopted as the reasoning of the court, it is again your submission which is set out at length. And at the bottom he says, considering the submissions advanced, they say, considering the submissions advanced by the learned counsel for the parties, as well as the facts and circumstances. This court intends to allow. What is that?
Acceptable. Not this, the order speaks for itself. I can't go beyond that. But I will tell you, Lordship, this.
If this is how the division benches are undertaking this exercise, we need to set them right.
But can I make one?
Therefore, this paragraph 32 of Justice Pardiwala's judgment, which was read out, para 33, perhaps we have to indicate to the High Courts that this is the kind of exercise that you need to undertake.
My Lord, I'll tell you, Lordship, where the challenge lies. And I leave not for a moment as a matter of not just as
dependency aside.
My Lord, no.
The High Court needs to at least reflect some application of.
No, I'm not disagreeing with your Lordship. I'm just saying something else. The challenge is this, and leave this case aside. Not this happens routinely with us because I am a practitioner, not primarily from the trial court, mainly in the High Court, occasionally in your Lordship's court on deputation. But the challenge is on deputation. Or they send me, my friends send me here. As long one day they'll call me back, I'll go back. No, Lord, I'll tell your Lordship, the challenge for every High Court is this. Justice Pardiwala takes a view. I know it's a detailed view. We have a series of judgments coming from Kashmira Singh onwards. Kashmira Singh. So let's divide it into two parts, not the law, for a minute. The first part is not, we are looking at the 60s when appeals used to be decided when court said there's no occasion. Then in Kashmira Singh, the court wakes up and I can show your Lordship that judgment to say that, look, what is the point? You admit the appeal, you believe there is something in the appeal, otherwise you would not admit it. You can also dismiss it in cases. There is no mandate that it has to be admitted on the first day, though it's a first appeal.
That's not how it works.
My Lord,
once it is an appeal against a conviction,
my Lord,
be not to case.
My Lord,
as a matter of course, we admit
my Lord,
never do I remember a single instance of a criminal appeal in a 302 matter being dismissed at the threshold.
My Lord, I must tell your Lordship, and I have learned a lot in this court that even in death penalty cases, there used to be a practice that death penalty came up to this court, leave will be granted automatically in the sentence state, unless it was really a no evidence case. But two things have happened, not in now over the last 3.5 decades, I've learned this lot, that here at the first stage also they're being dismissed. And
death reference cases.
Death references are dismissed, not, and death is, and life is supplanted with death also. So let's not, I must tell your Lordship, there are even those cases. The point I'm seeking to make is this. There is a fine balance, and I'm just telling your Lordship on a conceptual plane, not my Lord's experience is not different than mine. But I must tell your Lordship that in practice, yes, appeals are orderly admitted being a first appeal, but they can be dismissed. So the conceptual argument was, way back in the 60s, that if there is an appeal and you're not going to hear it, you must consider bail. That is the position in Kashmira Singh, Angana, and recently in Antil's case. That's Antil also deals with this, paras 54 to 57. Then, my Lord, we come to the second stage where your Lordship said that, look, there must be some merit-oriented merit consideration. And the merit consideration, it's a very fine line. If you cross the Rubicon, it'll impact the appeal. If you don't cross the Rubicon, it may fall short of the desired test. So this is the fine-tuning that is required, and with respect to though that judgment deals with it, eventually it does go and it dismisses. Now the challenge not for every court is this. If reasons, how many reasons or how much reasons? If you,
how do you word it?
And not how do you word it, because what becomes crucial is, if your appeal is to be decided, let's say 2 years hence, advantage or disadvantage may be taken of the observations, and that is a concern, Lord, which is there. So, behold this matter, and I must say this, Lord.
Your caveat is also not added. Whatever observations we have made are only for the purpose of granting bail and not to be taken into consideration. That at least is the usual caveat which is added even by us when we grant bail.
My Lord, if I may just...
This bench obviously is uncaring of all norms, unfortunately. And I can also tell you, in the High Court, we had devised the system of granting bail if the person had spent 5 years of actual incarceration and subject to exceptions being carved out. Some exceptions had been carved out, death of a woman, killing of a woman or a child,
or if they were eyewitnesses to the incident as recorded by the trial court. In those cases, even if it crossed the 5-year limit, no bail.
In fact,
but some sort of practical solution needs to be devised by the high courts. Each high court seems to have a different one.
May I suggest this? May I suggest this? And I'll leave it to your lordship. But so far as this matter is concerned,
we'll send it back.
My lord, I have no difficulty. I have no difficulty. May I just say this? Let the order go back. I would only request, subject to what your lordship believes, but let them be on. Not they've been on interim. They've been on bail now for a while. Let it be considered.
We don't know whether the High Court is in a position to take up the matter.
No, not. Let it go back and let the bail be reconsidered, not on its merits. Today, Lord, if your lordship feels that this is an unreasoned order, which is their argument, then let me at least have a chance to place my case before the High Court and let it consider. The second issue, not more crucial, other than this. At some stage, whether this matter or another matter, and my lord may send this back, but on the other aspect of the matter, my lord there has to be a larger consideration as to what are the parameters. In fact, Lord, in Satyendra until when I'm in amicus, the Honorable Bench had requested the union to consider whether there should be a bail act, because this is a challenge which is being felt not only at the High Court level, but even at the Appellate Court level when the Session Court is deciding an appeal. Now, one is to give or not to give, then to give on what parameters. And this aspect of the law needs some kind of clarity, if I may say so.
You will be appearing before the High Court as well, so you can go on.
They better
permanent deputation.
Lord, for a while, till your lordship sends me back, Lord, they better counsel them, not they'll take somebody good.
So just,
my lord, may I just say this? There are two of them. One is a 70-year-old gentleman, the first one.
Very well, we'll grant you protection for a limited period, and I'll request the Chief Justice to see that the matter is taken up.
Great. So my request is that if my lord finds these orders palpably not correct.
There's no reasoning.
No, that's what I'm saying. Then
the
it has to
argument
be
is that refer to, and it's
it has to be set aside and they have to surrender. That is the procedure which is always followed by this court. Sorry.
They have been on bail since what?
This is December. Since December, not 9 months now.
And first the father was granted bail, then the son.
December 24 and January
25.
On parity, the son gets bail. And in both, if my lord sees the first para itself, High Court is noticing this is the same.
They are now finding fault with the court itself. So they should not be penalized for that.
So, but
we can fix the time frame for the High Court to take up the.
So the problem is that if in a case of this nature and gravity, where the kind of injuries that were caused to the person,
I have a lot to say on merits.
That is what Justice Padiwala feels.
I will be happy to argue.
We'll keep that issue open.
Well, Lord, I'll be happy to argue merits because of the merits. The main man was not even there. Your lordship is not touching that.
On the ground that it is an unreasoned order, we should be going into that.
So they should also surrender. That's what I'm trying to say.
Leave granted. Having heard the learned senior counsel appearing for the parties, and having perused the improved orders, we are of the opinion that this is a fit case for the High Court to reconsider the issue. We find from the improved orders dated 13/12/2024 and 17/1/2025 that no reasoning whatsoever has been offered by the Division Bench of the High Court in support of its ultimate decision to grant suspension of sentence pending the criminal appeal to both the respondents. Not say both the respondents. Just pending the criminal appeal. The submission made by the learned counsel for the convict was referred to in each of the orders at length, and by boldly stating that upon considering the submissions advanced by the learned counsel for the parties, as well as the facts and circumstances of the case, the court intended to allow the application filed under Section 389 CRPC on conditions. The orders, therefore, do not reflect any application point, much less any cogent reasoning as to what weight will be High Court to grant such relief pending the criminal appeal despite the conviction of the convicts for an offence under section 302 of PC. It would be appropriate that the High Court is mindful of the decisions of this court, culminating in the recent judgment of this court. Recent judgment. There's a later judgment.
No, no, there is that one, and I want to just your lordship say, and Kashmir Singh is well known. I'll give those.
We said earlier judgments also, so whoever is.
Might not be put it, otherwise I may not, there may be, I'll just give it.
Give the citation, earlier judgments.
Not earlier judgment.
Starting with so and so, and culminating in the recent judgment.
This is good enough.
Prakash Sahni versus Jaishankar Chaudhary, 2023, 6 SSC 123, and particularly paragraph 33 thereof. The appeals are accordingly announced, setting aside the postdated income notice dated 13/12/2024 and 17/1/2025, and remitting the matters to the High Court for consideration fresh, keeping in mind the fact that the responding numbers 2 and 3 in these appeals. This is a single SLP or
not single SLP against two orders, my lord. Also, will be numbered twice, not two numbers, not two.
Normally it should be two.
They're not because they filed it as one paper book, but there'll be two numbers.
So the official respondents, considering the fact that the official respondents in these appeals, the convicts, the convicts named so and so have been on bail pursuant to the suspension of sentence granted by the High Court. We did $2 from a year of appeal that such relief may be extended for a further period of 4 weeks. We would, however, request the Chief Justice of the High Court of Madhya Pradesh at Korea to the High Court
is Gwalior.
They have a separate.
No, Gwalior Chief Justice is in Jabalpur. My lord, but he sits in Indore. There's one Chief Justice.
So that the Chief Justice is Gwalior. Deciding that.
Or Chief Justice as the case may be.
We request the division bench at Gwalior presently dealing with the examiners to give priority to this matter and take it up for arguments and hearing within the aforestated period of 4 weeks, so that the same can be disposed of as expeditiously as possible. The appeals are allowed to get frustrated extinction.
Well, would your lordship like to? Would your lordship like to do something the High Court didn't do, to say that you've not expressed a view on merits of the matter for the High Court to decide?
To make it clear that we have not expressed any opinion on the merits of the matter, and all issues are left open. We addressed all aspects of the matter are left open. We addressed by the division bench.
Well, only one issue I foresee. If it doesn't get decided in 4 weeks, they'll come for extension of time.
But we undertake not to take any adjournment.
No, but I see that.
But we are keen. We don't want to lose that. We have 4 weeks.
We would expect that the High Court will at least.
But they should
sense a nudge when a nudge comes.
No, everybody's got to nudge.
No, they should surrender on 30. If I could.
My learned friend, let it be like this. Not we here. It's our keenness to get it done as early as possible.
When the High Court doesn't give in to a nudge, then if it comes to it, we'll also have to give a push.
Lord, it's our desperation now to get it decided more than my learned friends. They didn't even appear in the High Court. I'm deeply obliged. But on the other issue, Lord, my request is that someday my Lord may consider. But your Lordship noted the other judgment, and
the other judgment also.
Also, it's come in the judgment. I'm deeply obliged. Grateful.
It is a curious case.
8. Mr. Krishna Balaji Murthy.
No, but
is your colleague.
Is my colleague.
Was he present in the first court when we passed this order?
No, Your Lordship. Only I was present. I am the AOR. This was, Bombay was the.
Because he seems to have gone before the arbitrator.
Yes, Your Lordship. So
But were you not aware of which Aman Sharma we had?
Atul Sharma.
Sorry, Atul Sharma we had.
I'll tell you, Lordship. I'll tell you, Lordship, what happened. Your Lordship, Section 11 was being argued by me. Mr. Atul Sharma, who's the.
He was present
in court.
I don't recall his face, but
Your Lordship,
the matter was present in court and he was willing to take the
matter.
assignment.
Yes. So, Your Lordship, the Chief Justice had appointed him. Now, typically what happens is that the person who is appointed in court ought to have given some name and number and email details. It seems to have been given, but it didn't get recorded in the order. I have been informed that that name and number was given. Now, I receive an email from an Atul Sharma from a generic email ID or from gmail.com. So, I forwarded to the Bombay team because Bombay is the seat of the arbitration and they are going to take care of the arbitration in future. Now, they conduct a preliminary hearing. In the meanwhile, the registry phones me and then tells me that this issue has happened, where the other gentleman has, I have then issued a confirmation to them, the person who I recognize in court, who had appeared at on that point of time. So this is the confusion.
How many hearings did this gentleman hold now?
Only both of them have held the preliminary hearing where they have given only a schedule. Both parties have confirmed that they are wanting to go forward with the person who was appointed by this court on the relevant date.
But why did this gentleman accept this assignment? If he wasn't in court, how did he think that we would have suddenly picked him out of the blue?
Your Worship, I mean, I'm just thinking out loud that if a person from the registry phones and says that the court has appointed me and the name is reflected in the order.
That three other persons, this name is very common.
Yes.
So they called several people. And those people at least had the graciousness to say, no, it wasn't I. Whereas this gentleman seems to have said, all right, give it to me. And now he says, I've had a sitting, I'm not being paid any fees.
I won't be in a position to comment on what his view is. But in fairness, what
the arbitration at all, who did it in the first instance?
Because it was coming from a generic ID, even we were not able in a position to point out that he was not the right person.
As the general counsel for the petition. In the arbitration petition, vouches for the fact that Mr. Atul Sharma, an advocate from Denton's Link Legal. That's a firm, is it?
It's a firm. It's a
firm. Legal firm. Was the person who was present in court on 5/8/2025 and was appointed as
7th May.
5/8 or?
Your Lordship, 7th May was the order.
7th May. Why does this say 5/8? 7 on 7/5/2025 and was appointed as the arbitrator. The registry shall take steps to inform the other learned counsel by the same name who appears to have entertained the arbitration erroneously, be it for whatever reason, so that the correct arbitrator, so that the arbitrator who was actually appointed by this court can proceed with the matter. As we are informed that only one hearing was conducted by the other learned counsel. We are of the opinion that there is no necessity for any payment of fees.
In fact, the registry has already communicated this to the other gentleman.
He seems to have said that I have not been paid.
No, he
But
seems
the
to
Supreme Court says that
he seems to have said that I won't want don't want to comply with the registry's letter, but because of the point.
Says so, I will hand over. Is disposed of accordingly.
Obliged.
Item?
My lord,
77.
77, there's death in the family of the senior.
Death in the, but you can argue. There's a senior.
The whole road is waiting only for this patch. Whole road is ready. Only this patch. Just have a look at this.
But this project, one thing we couldn't understand, Mr. Nadkarni, it says corridor project. That means there will be industrial concerns on both sides of the road, or just the road will be there?
No, it's an integrated project.
Project.
Integrated project linked with
Because
so many.
their argument was that only 400 meters of the road is left. Why do you need 6 acres?
Look, please see this. Just see this. Just have a look at this.
So you don't have a project. It's not just a road by itself. There's a project integrated.
And the road is ready now. Just see. Not the top road is the Bangalore-Mysore road, which also we have constructed. Now this is the link road. Now please see the yellow portion your lordship sees.
Yes.
The yellow portion is this particular disputed.
No, but would there be something on both sides of the road which is also part of this project?
No, not on this link road. This link road, the whole road is ready except for this patch.
But why would you need 6 acres for this?
No, it's a 6-lane road. It's a 6-lane road. And it has shoulders on either side.
It has shoulders on.
Yes, yes. Not that challenge earlier saying that occupancy, all that was dismissed by the High Court. Finally, the government acquired. And it's delayed only because of this.
He wants a date with the death in the family.
Let's stay for tomorrow.
We can't give you a short date. Any of letters?
Miscellaneous day. Sudden death.
You could have made some other alternative arrangements.
Only
Not as if there's only one
morning,
council here.
in the morning he had gotten the information that he had to go back.
But tell us how you get over the fact that there's a notification now. Once an acquisition takes place, it is not for the court to look into whether they need the land.
Lord,
if
here in
every
the
acquisition is to be subjected to this kind of scrutiny, where will it end?
Lord,
The procedure prescribes
just one thing.
entertain your objections.
In the High Court yesterday, the matter was listed, the miscellaneous appeal. This was out of the interim order. There he took time saying that SLP is coming today.
Oh.
I mean,
This order which has been passed, what is the date? 18/10/24. That order records your objections, deals with everything.
But physical hearing needs to be given. But
where is it?
And
then there's a
senior will be in a better
once there
position
is a
to
final
rattle
notification
notification.
issued. After that 18/10/24 order, 10/1/25 final notification came. Once the final notification comes, where is the question of the court going into?
but he appeared to his lawyer also.
Do you need 6 acres? Do you need lesser? Once they decide as to this is the extent that we require and they acquire it in accordance with that procedure prescribed under the
They
Act,
require only 400 meters.
it is not for you to decide. It is not even for the court to decide.
Single judge has.
Once they acquire the land under the notification after following the due procedure, that's the matter. It is for them to decide how much they want.
The engagement matter, Lords, the senior would be in a better position to address.
In any event, we are telling you, even if your senior comes, we are not going to interfere.
Any short date maybe.
So whether your head rolls or your senior's head rolls is the only issue. So we'll give you a date, but it can't be near any time soon. When counsel for the petitioner seeks an adjournment on the ground of bereavement in the family of the learned arguing counsel.
Lord, may I just make a request, because there again they take time saying that this matter. No. I want not a clarification that this will not come in the way of the High Court to decide the.
13th October. Make it clear that pendency of this special petition, which is yet to be entertained, shall not be taken as a ground for stalling or adjourning any pending matter.
Obliged, grateful to you.
Obliged.
Please, your lordships.
Dismissal of an early hearing application, myself.
Lordships, may I?
Two orders. We have 2 orders.
2 orders, lordship.
Why? How many orders do you need?
Lordship, may I submit, lordship?
Normally, if you get a date by way of an order, early hearing application is allowed and a date is given.
Please.
If the matter is not listed on that day or it doesn't reach, you address a letter to the registry. You keep on filing one application after the other.
Two applications, lordship. I had been patient. If my lords may only appreciate 2 things, lordship.
first application was in 2021. It was mere a partition shoot, which is at page 132. May I show Lordship the order?
We've seen the orders.
Lordship,
Once you have an order.
So then
you have an order.
It never
And then
came.
again in 24.
Now what I'm saying, Lords, that of course it's High Court's business, Lordship. I have no one to say. But there will be.
We are not going to arrange the board of the High Court.
No, only thing.
Or monitor it.
Please, Lords, I'm not on that. I'm not even.
And against an early hearing application dismissal, we are not going to entertain itself.
Please, Lords, I'm not wanting an interference. Only I'm saying is if it could be remitted back, just that in light of the previous orders, this could be.
Right, letter. Why did you invite this order in the first place? You already have 2 orders. But all you had to do was write a letter to the registry and say that the date's been given, please place it before the appropriate bench. That's all.
Only
keep on filing one application after the other. Much more time is taken up in these unfortunate, unnecessary applications.
No, Lordship. May not take that way because there are like some respondents have even
The
died.
number of IAs that the High Courts have to deal with.
Please, these kind of I appreciate and no one to comment on that. Only thing I'm saying, Lordship,
then Lordship,
if one thing may be observed, that if a fresh application is filed.
However, we find no grounds made out to interfere with the impugned judgment passed by the High Court. Further, we clarify that in the light of the earlier orders secured by the petition for the early hearing of the matter, it would be open to him to address a letter to the registry of the High Court seeking seeking the listing of the matter in terms thereof.
Great. Much obliged.
Milord, this is a notice has not been issued as yet, Milord.
Perhaps it is a case where we need to invite counters from the
Milord,
the SP, the SSP, as well as the ASP also.
Milord.
Because there's a larger issue here. It's not just this case, whether there are merits in this case or not.
Understand.
A larger issue is when there is a complaint under POXO and you don't even register a FIR.
Yes, I completely admit on that point. I may not have any case.
Extremely
if the POXO, Milord, may I clarify one thing, Milord?
SHO is being hauled up, but what about the superior officers? They
superior officers
and they do nothing.
No, Milord. Yes, if they had not done anything, then I have no case.
Let them say it. So we'll issue notice. Thereafter, you can
issue notice.
Issue notice and invite affidavits from them also.
Personal affidavit.
From the petitioner number 3 and 6, is it? Are they the ones who are directed to be proceeded against? The High Court directs that
ASP
should be initiated against the SHO and also the
ASP and SSP.
ASP and the SSP. That is petitioner number 3 and 6. Is that correct?
Yes, sir. Petitioner number
3 and 6.
Senior Superintendent of Police 3 and 6.
Issue notice. Petitioner number 1. 27th October. However, considering the directions of the High Court in the impugned order, we think it would be appropriate. Don't say, however, given the directions of the High Court in the impugned order, we consider it appropriate that the Senior Superintendent of Police, Patna, and the Additional Superintendent of Police, Danapur, Patna, petitioner numbers 3 and 6 file their individual affidavits in the context of the issues highlighted by the High Court in the impugned order.
Look, may I say one word, then Superintendent SSP and then ASP.
Senior Superintendent. They are not continuing now.
No, I'm not continuing.
Then Superintendent and the names are not mentioned in the order.
I will ensure that because I
in the
name has not been mentioned because no notice has been given to them at the time of hearing. Will Lordship has notice in the entire SLP?
In the SLP also.
And the interim order to continue.
Earlier interim order should continue to operate.
But should I ask them to engage for another?
Engage counsel also, that would be better. Once we are looking into their conduct, it's better that they are represented. It would be open to them to engage independent legal counsel to appear before this court on their behalf. 11.
Yeah, please, notes.
Yes.
And also the matter has been settled and the settlement agreement dated 23/5/2025 has been filed. The translated copy has been filed on 13/8/25.
You don't want to file an application before this court, you want to file.
They're proceeding with the mutual consent divorce in the lower
One aspect though, you are appearing for the husband.
No, I'm appearing for the
You're
wife.
is it?
Yes, petitioner.
Husband.
I am appearing for.
You said in the agreement, settlement agreement, that you would be paying 3 lakhs.
3 lakhs.
3 lakhs to the wife, but the next sentence, we will not accept it. The daughter is and will remain in the custody of the first party. All expenses for her education and marriage will be borne by the first party. That is, you're giving the responsibility to the wife. First party will not file any future cases against the second party for her or her daughter's maintenance. She has a right by birth in ancestral property that you have. There's no question of extinguishing that right by way of this settlement agreement. She is not even a party before us. So her rights we will keep open. If you have ancestral property, she has every right to claim a share in that. Unita Sharma. So there's no question of your trying to shut her out there. So subject to that, we will say that in the light of this settlement agreement, this is a, what case is it? It's a DVC or a domestic violence.
Domestic violence.
That's already been quashed by the High Court now. So that order will attain finality.
Yes.
And you will be withdrawing this specially fetch.
No, my lord, I'm not.
Then?
I'm just. We are just providing the settlement agreement. However,
the amount is yet to be paid also. 3 lakhs will be paid.
We have already filed the mutual divorce petition before family trial court.
No, this 3 lakhs have already paid it.
No.
You've not paid it. When will that be paid?
The family court had asked both the parties to withdraw all the petition pending before the all.
Then you will have to withdraw this then. If that is the condition that the family court is insisting on.
On last date of hearing, family court had asked both the parties. No.
Is that a fact?
My lord will withdraw then after the settlement agreement.
Leave granted. So let's say the petitioner is before this court, agreed by the judgment dated 17/6/2019, passed by the High Court of Gujarat at Ahmedabad, quashing the proceedings in domestic violence application number 300 of 2016, filed by the petitioner wife. However, during the pendency of this petition, the petitioner wife entered into a settlement agreement with her husband, respondent number 1, and the translated version of the said settlement agreement dated 23rd May 2025 is based on this order. In terms thereof, the parties have already filed a mutual consent divorce application before the family court at Anand in the state of Bengal. We find that one of the conditions agreed upon by and between the parties is that the husband dash respondent number 1 would be paying a sum of rupees 3 lakh as permanent maintenance to the petitioner wife, and it has been recorded that the petitioner wife would not file any future cases against the husband dash respondent number 1 either for her or for her daughter's maintenance. We must clarify that this condition would not bar the daughter, who is presently a major, from claiming her independent rights, if any, in the properties of her father, respondent number 1. The parties cannot extinguish the rights of the daughter even by way of mutual agreement. Clarifying this legal position, we accept the request of the learned counsel. What is your name?
Ananya Arora.
Yes. That we accept the request of Ms. So-and-so, learned counsel for the petitioner, to withdraw the special petition, enabling the petitioner wife to pursue the mutual consent divorce petition filed before the family court at Anand. The special petition is accordingly dismissed as withdrawn, but subject to the clarification noted here in the pending application.
My lords, in this matter, my lords, out of the FIR in question, there were 4.
All these other persons were also in the same FIR.
Yes, my lords. Annexure P8, 12 and 13.
What do you have to say?
My lord, I appear for
This is for
DDA.
DDA.
My
You're
lord,
saying some interest.
my lord, the
portal
interest composition of about 25 lakhs plus the restoration charges of another 1 lakh. And the few
But still to be paid, is it?
still to be paid. My lord,
Not paid full amount.
Please have annexure P14. Please have annexure P14 at page 8. No,
The other persons
No,
seem
no,
to have
have
paid
paid
the full amount.
please have page
They
8.
paid the full
my
amount.
lord, here the
Ma'am,
paid
let me-
only the.
No, let's have clarity on this first from the DDA. Thereafter, you can respond.
My lord,
The others whose quash petitions were allowed,
my
they
lord,
paid the full
I'm
amount.
instructed to say they had paid. Here in this case, it was a principal amount of 4.5 lakhs, but a plus an interest that came to about 25-26 lakhs. That is not paid. My lord, the principal.
What kind of interest rate do you?
My lord, it will be because what was due to us at a particular time, my lord, had not been paid for years. So that's how the interest composition.
This is
will
from
be.
1988, is it?
88, my lord.
My lords, please have annexure.
Paid in
Please have
2017.
annexure P14 at page 88.
Apart from the fact that they defrauded, my lord, that is a big time. But even on the financial part, my lord, it's a big fraud. It's a public money, my lord, that they sat over, refused to pay, my lord, colluded to show that it was a sister when it was not.
Yes.
Please have page 88 at annexure P14. P14 at page 88. May I please read? Counsel for the DDA states that the competent authority has recently retired and therefore he has not been able to take instructions. In this application, he further seeks time for further instruction. Learned counsel for the petitions have been without prejudice to right and contention. He shall deposit the amount of rupees 4,49,555 with the DDA, which according to him is the amount which petitioner is willing to deposit to put a quietus to the matter.
That was your offer. Where did they accept that?
Now, please. Now, please have annexure P15.
You paid that amount.
Now, prior to
Where
that,
did they accept that this is the actual
now,
amount that is?
please have the further payments which were made further.
Where is that?
My lords, may please have those payment receipts. It as is at page number 37.
Oh.
The annexure P3.
37.
One is at 37, my lords. And thereafter, I again deposited an amount at
37.
37, my lords. Page 44 also, my lords.
1,688.
And now, Please have.
This was in 85.
Now, please also have annexure P40, P5.
This is not the unearned income.
No, my lords, please again have.
Why are you showing us 37? This has no relevance.
Now, please have page 55.
We are asking for the unearned income which you are supposed to pay.
My lords, now please have annexure P5.
P5. P5. What is this?
Again, the conversion charges.
Don't show us unrelated payments.
My lords, if there is any demand today, we are ready to pay that.
They are saying
no,
that the notice due.
No, my lord, that notice still has not come to us. We will comply with that.
My lord, may I submit?
We will comply with that.
My lord, we'll put on paper the demand here before my lords.
Right.
My lord, because once it ceases here, such.
No, if they're expressing willingness to pay,
So my lord,
demand as on date.
the demand as on date.
Then comes before the DDA, Delhi Development Authority, should place on record the current demand made by the authority against current demand as it stands as on date against the petitioner.
My lord, may I submit?
And
my lord,
please record
the event any demand notices were issued in the recent past.
My lord, they were not.
May also.
They were not. My lord, may I submit? We have not. And even otherwise, my lord, it should not come as we are ready with the quashing of the FI. We are not.
Please, you get the total amount.
My lord, but my lord, if such
if suppose that amount comes, then this lady will also become part with all the others.
So my lord may make it as a direction if deemed fit, my lord, because if we say that
we have not said that you have offered.
My lord, if
you said that, then council shall place on.
In fact, my lord, may I submit that upon paying of these monies, which I do that.
These frauds seem to have
please.
All kinds
Please, this is
underlying them.
This is 3 FIRs caused similar allegations against all of them.
Others have paid, you did not pay.
No, at no point of time any demand was put to me.
Now at least you settle it if you're ready.
Yes, definitely.
That is.
Lords.
How much time would you require?
My lord, about 3 weeks.
Let's from 22nd September.
Obedience.
Lords. 6th October.
A day after.
6th October.
My lord, a day after.
Then a week later, 13th October.
Very well. Much obliged.
Oh, it's not very well. 7th October.
My lord, I am in Ahmedabad.
Okay, very well. 13th or 14th?
13th, 14th.
14th.
Much obliged.
Your Lordship, seeking a short passover in this matter, arguing counsel is on his legs in another court.
You want to pass it on now, but we have a 70 odd matters list.
I bow down.
No question of taking up any passover. You don't want the matter to be taken up today, you'll have to go pay and do it. And council says passover. However, we are not inclined to accept the request given the number of matters listed before us today. List on 18th November.
May I please, my lord? In this, I appear for the state, lord. We have just.
State is still not served.
We appear for the state. We have just.
State?
We have just entered our parents yesterday. Just give me 4 weeks time to file my wakalatnama as well as counter.
Very good. The state of Jharkhand needs some time to file a counter document. That shall be done within 3 weeks. 4 weeks, you want?
4 weeks.
4 weeks. Join the date with any will be filed in 2 weeks thereafter, based on 18th November.
I'm grateful. Please.
There's a letter for adjournment in 15.1. 15.1.
Please, my lords, I am appearing for petition in item number 15.
Millards, I am appealing for respondent 2 to 5 in 15.1. Millards, I have moved an adjournment statement for filing counter.
From council appearing for respondents. All the respondents, is it?
Respondent 2 to 5. Millards.
2 to 5. For respondents 2 to 5 in 15.1. Seek some time to file a number letter. Usual order.
Yes.
List on 18. Give me the letters.
Your Lordship, the states have filed the counter affidavit on 20th. I seek 1 week's time to bring the rejoinder on record. It's already prepared.
Now they say that 68,883 is the amount.
80, maybe typography, 555.
Why so much repetition in your counter? Everything, same thing said again and again and again. Distant turns, say it once, say it twice, say it 3 times. Counters have to be short. We don't have so much time to digest the same thing again and again and again. These counters come at the 11th hour. They come in the 9th. And then one paragraph after the other, same thing is repeated.
I'm sorry.
Are you paid by pages or? Please keep your counters crisp and short.
Yes.
So the amount is how much? 68?
68,555.
68,555. So put it to your client. We are now letting her off because of the fact that the offense was in 1998. Sorry,
1997.
99, and then the conviction is in 2009. The appeal is in 2025. So given the passage of time, we were more inclined to be liberal towards you and the fact that you are a woman. But if this is the amount that you have pocketed, then perhaps it's time you coughed it up. So put it to your client. If she at least returns this money, then we would perhaps be inclined to continue with the kind and liberal attitude. Otherwise, we'll have to review that. When it comes to the petitioner, seek some time to file a rejoinder with the counter filed by the state. Based on how much time do you require?
1 week time. 1 week time is to file the rejoinder.
Based on not 1 week, we'll give you a longer date, but think it over and come up with some instructions in this regard. 7th of October.
May I request one thing? Kindly call for the soft copy.
Soft copy
of the records.
Why do you need those?
Evidence.
You want us to go into the merits?
I place it on.
Wait for them.
Apply.
Wait, your Lordships had issued notice in the matter.
No, but Mr. Agarwal, where is the 313 examination? What was shown to us was the 281 examination. 313 examination was
Straight away. Page 232 is the type copy.
This is 281.
Well, that format.
281 examination is different from 313 examination.
I have the original. I have the original with
heading itself within brackets 281.
I have
a statement put to the accused during the course of the trial, not at the end of the trial.
I have Your Lordship, you see, I have the format. The format in brackets. The printed format has what the bracketed portion under section 281 of the CR.
There's no separate 313.
This is the 313.
Is that the fact, Mr. Mann?
Well, I'll obtain instructions, but I have seen this before. It may happen, but I'll seek instructions because trial court record
24 July 2015 is the date.
The questions put are perhaps similar to what you put in a 313.
Yes.
But the heading is 281.
The heading is 281.
But 281 examination is different from a 313.
It is, my lord, but I've noticed this before for 313 in Bihar, but I'll still have to confirm. I have seen this before.
But if this is a 313, then we'll have to.
Well, if this is the 313, then I would have beseech my laws to then remand it at the very least. But I'll confirm this aspect, my lord. I'll get it.
You need some time.
Yes, my laws would give me 3 weeks. Time.
During the state of chaos, need some time to examine the issue as to whether there was a separate section 313 examination by the trial court, and if so, produce a copy thereof.
In fact, my lord's problem with these matters is that when the appeal goes to the High Court and then this Honorable Court, whenever we seek documents, the PP and the SP's office say that all the originals have gone to the High Court. So if my lords would consider calling for a limited portion part 313, while I will also do this exercise.
Registry may also call for a copy of the 313 examination, section 313 CRPC examination of the accused by the trial court. From the record of the 313 examination. Yes. From the trial. The High Court has the record now, or the High Court has it?
The High Court ought to have it because they tell us that
from
High Court
oblique trial.
Oblique trial. And I'll also try and get it.
It's my duty to point out I have moved an application for suspension of sentence, but at the present moment, since your lordships are only looking at this aspect,
if that appears.
I was done with the requirements.
Minus 3 weeks, it'll be here. That's all.
23rd September.
I'm okay.
Grateful, man.
Between this letter.
We calculated a letter yesterday for a short.
We've already said this, perhaps the registry is yet to take note of it. Without indicating what the personal difficulty is not done.
Your Lordship.
We need to find the reason that you had satisfactory. Just saying I have personal difficulty, therefore I can't appear. How do we find it satisfactory?
Generally,
What is
the learned senior counsels instruct us not to specifically.
That can't do. Have you seen the circular? The present circular which is there.
I had the
Chief Justice's circular which says that letters for adjournment shall be entertained,
not
provided the reason is found to be satisfactory by the bench.
Yes, Your Lord.
How will we find it satisfactory when you don't even tell us what your personal difficulty is? The other day, one counsel doesn't want to disclose that there is a bereavement in the family. It's so secretive about a death in the family. You don't want to disclose that also.
Lordship, I am aware, but my counsel had to urgently travel home because of certain emergency at this place, and he's been appearing in this matter. He's
But you need to tell that, say that the council was called away out of station.
We'll make it a point in that.
Adjournment of the case should be considered only in case of bereavement in the family or medical oblique health condition of the advocate oblique party in person or such other genuine reason to the satisfaction of the honorable court. Genuine reason. How do we even know what is genuine here if you say personal difficulty? You might say that the weather is nice today, so I want to sit in my lawn. I don't want to come to court. Is that a genuine reason? Do we find it satisfactory?
The learned senior counsel is a practicing
Very well,
counsel in the
don't
Supreme
disclose anything. These
I
letters won't-
I got what is.
Unfortunately, the registry is on your side. I passed an order also asking the registry not to access these letters in spite of that this letter is accepted.
We'll definitely take this in future.
Yes. Accepting the request of the learned counsel for the
respondent.
Seeks an adjournment on the ground of personal difficulty on the part of the arguing counsel. Personal difficulty of the learned arguing counsel. The matter is adjourned. List 11.
Please.
Organized. 90.
Mr. Mutneja, Senior Counsel is addressing your lordship. Mr. Mutneja, Senior Counsel is addressing your lordships on the BC.
Who appears against you? No?
Wait, please, Lordship.
Mr. Paramjit Singh is the party. Ms. Sharda.
Yes, my lord.
You're also there? Both of you are appearing online.
Yeah.
Very good. Who's for the IOC?
I am for the IOC, my lords.
Yes.
My lords, in this case, one Khazan Singh,
yes,
his land was acquired. He had filed a revision.
Yes, Counsel.
That was one Khazan Singh. His land was acquired.
Yes.
He, against the award of the collector, he filed a reference under Section 18 of the Land Acquisition Act.
Yes.
That reference, during the pendency of that reference, Khazan Singh died.
Yes.
His legal heirs were impleaded as a party. Subsequently, and all
legal heirs were impleaded.
All except Paramjit Singh did not implead himself by filing a regular first appeal. Others filed a first appeal.
Before the reference court, he was a party.
Reference court, he died before the award, and they became a party.
Khazan Singh's LRs who were brought on record before the reference court.
No, they were brought on record in the regular first appeal before the Honorable High Court. Yes, in the regular first appeal, they were brought on record. This Paramjit did not file an application, or nor did he file an appeal before the Honorable High Court. Subsequently, he got the amount which was awarded by the reference court, but he did not file an appeal. Then subsequently, my lords, the Honorable High Court enhanced the amount. That enhanced amount, the other legal heirs filed an execution application, and that amount was released to them. Then, my lords, a year later, this Paramjit Singh sought to file an execution by putting his name in the list of persons.
Do we have a copy of the reference court's order before us?
My lords, that is not there. I'll place that on record if my lord wants.
But as per my dates,
yes,
Azam died during the pendency of the matter before the reference court itself.
Yes,
After the appeal was filed, he died during the pendency of the reference court proceedings.
Yes, he died during the pendency of the reference court proceedings.
Which were the LRs who were brought on record before the reference court?
No, my lords, they were brought on record in the regular first appeal.
No, before the reference court, the LRs were brought on record or not?
No, my lords.
The reference court order was passed in favor of the dead person.
It was after arguments that he died, and subsequently judgment was reserved, and subsequently he died. And therefore, in the regular first appeal, the other legal heirs became parties. This person did not file his appeal as he was probably abroad. And then the regular first appeal is allowed. Those a decree is passed by the Honorable High Court. That decree is executed. Then what this person does is he puts his name in the decree on his own and seeks to execute the decree for his claim. We clearly said that he was not a party in the regular first appeal, and as such, he could not have.
Yes, come.
Yeah. So we said that he could not have been, he is not entitled to this increased amount granted by the Honorable High Court.
Yes.
Now, both the courts, the trial court in Panipat, as also the Honorable High Court, do not decide this issue at all. Rather, the High Court goes on the issue that under Order 41, Rule 1, he is entitled to file an appeal and get the decree amended. But the issue is he's not even filed an appeal before the High Court. So Order 41, Rule 4 will not apply. And I had cited the judgment of the Honorable Supreme Court in Ramesh Chand's case, as also in Irshad Ali's case. These are 1996, Volume 4, 1996, Volume 9, Supreme Court cases, page 84, and 1997, Volume 7, Supreme Court cases, page 88. And I had cited a judgment of the Honorable High Court.
Please repeat the citations once again.
1997, Volume 7, Supreme Court cases, page 88.
And the earlier one? 1996.
1996, Volume 9, Supreme Court cases, page 84.
Yes.
Both these judgments, and I also cited one more judgment of this of the Honorable High Court of the Punjab and Haryana. That was in Civil Revision number 2811 of 2000. I've sent the copy, my lords, in which all these three, this issue is decided, and they clearly say that a person who does not file an appeal is not entitled to the enhanced compensation. He cannot file an execution. Now, the argument for my lord's kind consideration is under Section 26(2), the award passed under Section 18 of the Land Acquisition Act becomes a decree. That decree can only be set aside if he files an appeal under Section 54 of the Land Acquisition Act. He has not filed an appeal. The order passed in the regular first appeal before the Honorable High Court also becomes an decree. He is not entitled to the benefits of that decree, not having been a party out there. That effectively, and this is exactly what the Honorable Supreme Court says in Irshad Ali's case, that is 1997, in which respondent number 1 having 1/3 share, the first respondent had waived his claim for higher compensation for the above extent of the land, since the appellant had not challenged the award of the reference court and the award has become final to the extent of their share. They are not entitled to any higher compensation for the extent of 1/3 of the share. That is precisely my argument. He could not have done it. And second argument, of course, is that he has himself filed, incorporated his name in the decree without that being done by the Honorable High Court. He was not even entitled to it. He has misled the court.
Where is the order of the execution court?
My lords, yes. Prior to that, if my lords, I can show where he has incorporated his name on page 22. On page 22 at annexure P1.
Yes.
At item number 3, he puts his name Paramjeet Singh, sons of late Khazan Singh. And I took that objection at the first stage on page 26 in my response.
Where do you find his name? Paramjeet Singh?
At number 3, my lords.
At number 3. Yes.
Yes, Paramjeet Singh at number 3. Then I take this objection at the first instance in my reply at annexure P2 on page 26.
Where is the appellate court's judgment?
My lords, the appellate court judgment is not before my lords. I can place that. I can place that on record, my lords.
We need to see them to see who are the parties there.
My lords, I'll place that on record. Because, but I have taken this objection straight away in my response to say that.
The High Court doesn't deal with this issue at all.
The High Court does not deal with this issue.
Does not reflect any of.
No, it does not deal with this issue, my lords.
Aspects.
Neither does the executing court nor the Honorable High Court. None of them deal with this issue.
Place the appellate court judgment.
Right, my lords. I'll do that. I'll do that, my lords.
Appellate court judgment arising out of the order of the reference court shall be placed on the based on. How much time do you want?
My lords, give me 3 weeks time. I'll do that.
7th of the.
I would like.
20.
Please, ma'am. My lords, I appear for the petitioner in the matter. The respondent has not been appearing in this matter. My lords, service has been complete on one date. My lords may have the order of 7th of July. One advocate had appeared on that day, but nobody has entered appearance thereafter.
Did you check with him?
We tried to find out the number.
It's not.
We're not able to.
Not a regular counsel.
No, not an advocate.
No. What exactly is your complaint now?
My lords, it's a short issue. The district forum and both the state commission have held in my favor, and they have reduced the illegal demands which were being charged by the vendor, and also they have offered the delay penalty up to the date of actual possession. This NCDRC in revision, what it has done is it has said that the pricing could not have been changed. Although this is not a case of pricing, it was actually the bringing it in conformity with the original agreement. And secondly, the NCDRC in my lords may have page 7 of the impugned order. In para.
By the quantum of the delay compensation.
My lords, a period, because they have said that it will be till the date of offer of possession. And offer of possession in para 15 they say will be 2013. It was a conditional offer of possession which both the learned forums below have held. My lords may have para 15 page 6. Just right above para 16, my lords. They say the promised date of possession of the flat.
This is an extraction from some other judgment.
No, my lords, the extraction is only in the italics.
Well, after that,
yes,
promised date of possession.
The promised date of possession of the flat was 27/11/2010. The offer of possession was made on 23/1/13. It would be justified if the respondent builder get delay compensation as per the principle laid down by the Honorable Supreme Court in the above case. So this date, my lords, both the courts below have held that it was a conditional offer.
Let us see what the earlier judgment said.
Yes.
Read that out.
My lords, district forum's order, my lords.
This para 15, the judgment which
Yes,
has
my
been
lords.
extracted.
Oh, yes, my lords. However, the commission has held that there was a delay in handing over possession of the flat to the respondent purchaser. The appellant builder was liable to pay interest to the respondent purchaser by way of compensation. The scheduled date for handing over possession was 31/10/13. The appellate builder had issued the pre-possession letter on 31/10/15. As per the respondent purchaser, the appellant builder did not have the occupancy certificate on that day. The commission directed the appellant builder to pay the compensation in the form of a simple interest at the rate of 8% per annum from 1/11/13 till the date on which the possession was actually offered to the respondent purchaser. The appellant builder inter alia submitted that the possession of the flat was offered to the respondent purchaser in December 15 after obtaining the completion certificate for the building. Even though the agreement provided for delivery of possession by 31/10/13, the delay occurred because of various legal impediments in timely completion of the project because of various orders passed by the NGT. The delay ought to be computed from so-and-so period by taking into consideration the 6 months grace period provided in the agreement. Furthermore, the period of interest should close on April 2016 when the full OC was obtained as per the admission of the respondent purchaser herself in the complaint, wherein she has admitted that the appellant builder had obtained the completion certificate as late as April 2016 with respect to the delay in handing over possession. The respondent purchaser ought not to be allowed to reap the benefits of her own delay in taking possession. In the light of the aforesaid discussion, the period of compensation of interest must be computed from 1/5/2014 till 30/4/16 at the rate awarded by the Commission. The order of the Commission is modified to this extent. So, my lords, in that case, there was an admission on part of the party that when the occupation certificate was obtained. But in our case, my lords, none of this has happened. And even till date, there is no actual offer of possession because the builder is repeatedly giving us the enhanced demand, my lords. Both the codes below have reduced the demand, which has not been changed by the builder till date, my lords.
So even as on date, you don't have the flat?
No, my lords.
You've not taken any steps with regard to the positive direction that the flat will be delivered within 2 months?
My lords, we've written letter to them. My lords, we wrote a letter to them, but thereafter they are still.
You've not followed up the proceedings before the NCDRC. There's a positive direction here.
My lords, we've written a letter to them, but they are continuing to raise the enhanced demand.
And you've not taken any steps up. It's your lookout. So we are only concerned with your delay compensation. Promise date of possession as per the agreement till the offer of possession or obtaining occupancy certificate, whichever is later, within 2 months of the same, in which an interest of. Now, what is your grievance? This paragraph B.
My lords, my grievance is paragraph B because the Commission itself wrongly notes that the date of offer of possession is 23/1/13, whereas that was a conditional offer of possession.
There's no date mentioned here.
My lords, it's mentioned in paragraph 15. The part we just read in the beginning.
27/11/2010.
That was the promised date of possession. My lords, the offer of possession. My lords,
now the direction is to pay you from the promised date of possession.
From the promised date of yes, my lords. My lords, the issue is the date of when the possession was offered. My lords, may just see paragraph.
The offer of possession or obtaining occupancy certificate.
My lords, later on.
Certificate has come.
My lords, we later on found out that it has come in 2011 itself.
Occupancy certificate has come.
Was already there. Still, the possession was not offered to us in 2000.
Later. So, offer of possession, there's no offer of possession
yes,
till now.
Till now.
Till now.
My lords, there is an offer of possession, but it is conditional.
Where is that?
Yes. My lords, may see. My lords, may see page 39.
But if there's a dispute with regard to the quantum still due and payable, that's a separate cause of action.
My lords, I'll just show page 39 first.
39.
This was the first time there was an alleged offer of possession, which my lords may permit me to read it. This bears reference to the caption plot allotted by you, buyer's agreement executed by the company. We are pleased to inform you that the development of the aforesaid project is on the verge of completion. It gives us great pleasure to offer you possession of this.
They don't mention any amount.
My lord,
Amount of
page 40.
external development charges and internal development charges mentioned in the annexure may be revised due to change in EDCS IDC.
My
Whatever.
lord's page number 41 is the annexure to this letter. So, my lords, we were aggrieved by these.
Then that's a separate cause of action. Then.
My lord, this is my. So, all the genesis of this is from this letter only. They offer me possession, but
No, this letter is not subject matter of the.
My lord, this is the subject matter of the complaint. My lords may have the orders of both the district forum and the state commission.
No, but this demand has been set aside.
Yes, my lords. And they actually asked him to give a fresh statement of accounts, giving us what we are actually supposed to pay in terms of the agreement, which he fails to do. Yes, my lord. My lords may see page 60. No, my lords, I just stand corrections. My lords, the order of the state commission starts from page 64.
This is the district forum.
Yes, my lords. My lords, we'll see district forum is page 70, the relevant findings. My lords, the last 4 lines from the bottom.
Page 70.
Yes, my lords. If my lords may permit me to read, it has been observed that the possession has been offered to the complainant by the respondent first time on 23/1/2013, but it is also clear that the same was physically not handed over to the complainant. Therefore, it stands clear that there has been a delay of more than 31 months from the side of the respondent in offering the possession of the flat. The learned counsel for the complainant has submitted that the complainant is entitled for relief on account of delay in construction of the flat and late offering of possession by the respondent, and on this point refer clause 28F. My lords, in 28F they reproduce the what is the rate payable. My lords may see 2 lines below that. Thus, we direct the respondent to pay a sum of ₹5 per square feet for the delay period of 31 months as discussed above as a penalty for delay. It has been further observed that the complainant, after receiving the possession immediately after depositing a sum of 177,898 with some objections, wrote to the respondent, vide his letter dated 4th February 13, that the payment was ready as soon as he received the details. But it has been observed that the respondent has failed to place any document supplying such details to the complainant. Hence, in a considered view, the complainant also becomes entitled for interest on the amount which the respondent illegally retained, used further, and failed to remove the objections, also failed to provide the details to the complainant asked by him. It stands clear that the respondent used hard-earned money of the complainant for that is a sum of ₹24,82,000 as shown in the interest statement account annexure A, and therefore becomes entitled for interest with effect from 5 to 13 till the date of this order, because still the physical possession has not been received by the complainant. Therefore, we direct the respondent to pay an interest of 9% per annum on the said amount. Then my lords may see the last few lines of parasite.
This question is left open.
No, my lords, in the next page 73, they said that
Further
yes,
clear that after adjustment of the amount,
a fresh statement of
is less or excessive.
Yes, ma'am.
Be paid to the complainant or recovered from the complainant.
Yes. My lords,
everything is left open.
My lords, may just see page 69. They have dealt with this aspect. My lords, I'll just point.
This 2013.
My lords, it is this. My lords, may see page 69. Yes, ma'am.
Lordship, Commission may mention item 23. After 23, I'm in a personal difficulty. I have a medical emergency at home, so I may not be able to be available today.
Keep it in mind.
Next Tuesday, it may be taken up.
Not next Tuesday. Once you seek an adjournment, you go to the.
My lords, my lord, in item 25 also I was seeing a request.
No adjournment.
No, in item 20, my lords, Miss Antasnoy Senior Counsel, we briefed her yesterday evening in item 25, but early morning,
now
there's a medical emergency.
Wait till the matter reaches.
I'm grateful, Lordships. Obliged.
Yes.
You were at
Well,
page 72.
Yes. My lords, if my lords may permit me, I'll just take my lords to the State Commission's order because that has upheld the findings of the District Forum. Yes.
Which page is that?
Yes. My lords, it starts at page 74. My lords, the relevant findings on that particular letter are from page 80.
80. Yes.
Yes. My lords, from para 13, they've dealt with the letter. A letter dated 23rd January offering delivery of possession to the allottees was issued by the opposite party on 23rd January 2013, subject to payment of a total balance amount of 4,61,000. Admittedly, the complainant deposited an amount of rupees 1,77,000 as is clear from exhibit letter P9 and raised an objection regarding the liability to make the payment of the remaining amount. The balance amount to be paid by the allottees is mentioned as 4,61,633. So, my lords, in this letter of allotment, they have raised some excessive demands. And my lords may just notice they have also on page 81, point B, they have raised an interest on account of delayed remittance, which is a penalty on me of 24,991. My lords, all these demands which are raised are dealt from paragraph 14 onwards. My lords, to para 17, and each and every demand they have, wherever they have struck it down, they have struck it down, and some demands have been modified and reduced, my lords. And in terms of the order of the District Commission. So, my lord, therefore, I'm saying that the letter of 23rd January 2013, which was raising some additional demands, those demands were modified and they had asked them to issue a fresh statement of accounts. And similarly, my lords may also have page 86, para 22 bottom, my lord.
The District Commission had left the issue open as to whether you are to be paid money or you need to pay money. What does the State Commission say?
My lord, the same thing they have also held.
But without that issue being decided, how would you be entitled to possession?
My lord, the only
There needs to be a clear finding as to whether you are required to pay money or you need to be paid money.
My lord, there is a my lord, as far as the demands which are raised in the letter of 23rd January.
Very well. If those demands are set aside,
demands
then the issue is yet to be decided. As
my lord, the only
they need to pay you.
My lords, the only there is some balance which will be required to be paid by us, my lords, because 99% of
that needs to be paid, is it not? Without that being paid,
yes, my lords, that in fact both the commissions have noted that we have been ready and willing to make that offer, and therefore that delay has been calculated from that day, my lords. See para 23, page 87. My lords, which is a letter written by me after the demand. In fact, after depositing an amount of 1,77,000 on 4th February, the complainant had written the above mentioned letters to the opposite party and time and again requested them to provide a correct figure regarding the balance amount, raising some dispute regarding the amount mentioned in Annexure A. Despite that, the opposite party did not provide the correct figure of the balance amount. As per discussions above in the detail and findings given by the learned district forum while passing the impugned order, it is clear that the figure of the balance amount claimed in Annexure A, which is that letter, my lords, was not correctly mentioned. The amount claimed by the opposite party was excessive. In fact, the complainant could not make the payment of the remaining balance amount, if any, as the amount claimed was excessive, and due to this reason, the opposite party did not agree to deliver possession. So, my lord, this was the exact dispute. We were ready and willing, my lords, but they were not.
So the concluding paragraph.
Yes, ma'am.
Not the concluding, but the penultimate. Paragraph 27. They are required to issue you a fresh statement of account claiming the balance amount, if any, within a period of 1 month after adjustment of the amount paid. Opposite party shall deliver possession. So did this happen?
My lord, then they went up in revision before the National Commission.
They went in.
Yes, my lord. So, my lords, the impugned order.
They did not give you a letter indicating what the correct.
No, my lords. And in fact, the National Commission has set aside both these orders. So, therefore, my lords, parties.
What now?
My lords,
this issue is not decided till.
My lords, they've not given a clear finding. That's the difficulty. My lords may just see para 14, my lords. My lords may actually see para 9, which records the contention. So from there it will be little more clear, my lords. 9A, my lords. The forums below failed to appreciate that the entire dispute was on pricing. So this contention has been upheld in paragraph 14.
You go on the issue of this jurisdiction.
Yes, which they have, jurisdiction they have not entertained.
Have this order, so far as securing the possession of the flat is concerned, it's for you to take necessary steps because they're positive directions.
Yes, my lord, that we will be taking. The only difficulty is that now they are raising excessive demands on interest portion, my lords, on my balance amount.
We don't know because this last portion also says the respondent, that is,
yes, my lord,
shall pay the due amount to the petitioner, if any, at the time of taking possession, if any. Therefore, that is left open.
My lord,
so that issue still remains open. What will be the dispute? That has not been decided.
My lords, the state commissioner specifically decided that interest charges cannot be levied by them.
Whatever it is, whatever amount they are now asking you to pay, you'll have to again go back to court because that issue has not been decided.
My lords, we are asking for we want the order of state commission to be followed, my lord, because that was the correct order.
With regard to delay compensation.
My lords, even
from when to when?
My lords, delay compensation till the actual date of handing over and also in respect of the charges which I am liable to pay them.
In spite of this order was passed when NCDRC's order is 2022.
Yes, ma'am.
And the time given was 2 months. And in spite of that, you also take no steps. They don't take any steps.
We come up in appeal.
So how would you be entitled to interest for this 3-year period now?
My lords,
you were to get possession within 2 months.
Yes, my lord.
And if there was violation of that mandate,
yes, my lord,
you had to take recourse to
my lords, we come up
under the act. You don't do that.
My lord,
here you are before us only with regard to the delay compensation. So where is the question of you getting interest for this 3-year period? Delay is also partly acted. They don't act upon it, you take no steps.
My lord, they write a letter to me in 2020.
You take no steps. There's a positive direction to hand over the possession to you in 2 months. If you don't take steps in spite of a positive direction, you can't take advantage of your own wrong.
My lord, but for the other people, compensation cannot be restricted till 2013, my lord. That's what in effect this.
No, it is not from 2013.
My lord,
you are wrong.
My lord, may see
paragraph B.
Yes, my lord.
Please read it.
My lord, the petitioner is directed to pay delay compensation to the respondent via @8% per annum on the deposited amount from the
promised date.
My lord,
promised date you get from that paragraph 15. What is
my lord, still my lord,
promised date is 27
yes.
2010.
My lord, further, my lord, may just read till the offer of possession, which is
obtaining occupancy,
which according to them it's 2013, my lords. That is my difficulty. Which the state commission as well as the district forum had held till the actual handing over. My lords, at least till 2022 when this order was passed, I am entitled for that compensation of delay in handing over of possession, my lord.
All these are paper reliefs because even the relief that you secured from the NCDRC, you did not even take steps to see that it materialized. So one more paper relief you want, that's all. When was the service affected? 23 itself. This company is still in existence or it's not there anymore?
It is in existence, my lords. My lords, in fact, they've been raising demands with now levying interest at around 12 lakhs or something first.
Let notice be issued to the respondent by the registry, informing it that the matter pending before this court, that is the special petition arising out of the judgment 22/11/2022 passed by the National Commission, Consumer Disputes Redressal Commission, New Delhi.
Informing about the pendency of the present SLP before this court arising out of the judgment dated 2022 passed by the National Consumer Redressal
And
New
that
Delhi.
said special petition will be taken up for final hearing on the next date of hearing. The registry may also inform the respondent company that it is required to enter appearance in the event it does not want an adverse order to be passed against it without.
My lords, they permit me to file some additional documents, my lords, whereby we fall. Much almost.
Your Lordship, our office is in the basement and it is severely waterlogged due to persistent rainfall. Yeah. Your Lordship, our office is in the basement and it is severely waterlogged due to persistent rainfall. We are unable to retrieve the documents and the files and briefs.
Your office is beyond reach.
So,
Your files are underwater now.
Your Lordship, actually the issue is that our computers have also started sparking, thereby creating the hazard of electrocution.
Your Lordship,
on the petitioner.
Yes.
For the petitioner. WBSSC compensation.
Lordship, on the last date also, the Lordship has categorically recorded in the order that
you can get in touch with the rain gods to it this, so that they can access the office.
Your Lordship, they are sitting on the public. Lordship, we can just mention 2-3 documents which clearly show.
Otherwise, you go, if you know swimming, you go get their files for them, then you can get them.
Lordship, you can come and examine the office.
As your
counsel for the petitioner states that she is not in a position to advance arguments as the office and the files therein are inaccessible due to waterlogging. List on
any short date?
No short date.
Your Lordship,
any of recovery compensation must be excess compensation. The stay has been operating since 2023.
So, Your Lordship, it is in their favor. They are sitting
now, but it's been in operation for more than nearly 2 years now. Oh, over 2 years.
Your Lordship, this compensation pertains.
This is a case of actually fraud. They have.
In any event, you'll also have to respond.
Taken compensation beyond their
affidavit filed by respondent number 5. Respondent number 5's counter gives full details of the excess compensation paid.
Yes.
Who is respondent number 5?
Yes.
NHA.
So they've given full details. You will have you not filed a rejoinder to that. If you don't file a rejoinder, we'll have to take what they said at face value.
Even if Lordship has ordered that no further adjournment should be granted. Lordship has already ordered that no further.
That would be subject to other exigencies.
Yes, yes.
Your Lordship, in the initial today says saying that there was in this synopsis also there are many errors in the synopsis. Their synopsis. They are trying to mislead this court. They force the documents of the
point out. We've already done that exercise in the morning. I no longer have the energy to take any more advocates to task now. So you reserve that for the next day. If you have tried to mislead us, at least take steps to unmislead us by the next day.
Absolutely.
Lordship, the money should be returned with interest because the other landowners have to be.
If you succeed, you'll get back the interest also. They can't keep your money. I know interest.
Item 22, Milord. The question involved is that whether the disputed land is a private forest or not.
Yes.
Milord, the petitioner has acquired 6 acres of land by virtue of 5 title deeds, Milord. That is in the year 2004. And
all the title deeds are of 2004?
Yes, Milord. About 2004. And the government, the respondent has
act is placed on record?
Yes, my lord, I have appendix, my lord.
Where is it?
The appendix 1 and 2, my lord. Appendix 1 is Madras Preservation of Private Forest Act, and appendix 2 at page number. Page
private forest.
Yes, that is at page number 50, my lord, appendix 2.
What does it say about vesting date?
Vesting date is on 10/9/1971. That is the appointed date.
Appointed date.
Yes, my lord. The notification
is automatic. The vesting takes place automatic.
Vesting by virtue of section 3(1), my lord.
3(1).
3(1).
Yes.
By notification, my lord. But there.
Ownership and possession of all private forests under virtue of this act stand transferred to.
It is not automatic, my lord.
Stand extinguished.
They have issued a notification. By way of a notification, Annexure P2 notification, the vesting has been made, my lord.
With the effect on and from the appointed date.
Yes, my lord. But it has to be automatic. But it has to be my lord. But it has to be notified, my lord.
Where do you get it that it needs to be notified?
But my lord, by Annexure P2 notification only they have.
The Act does not speak of a notification being a condition precedent for the vesting. It says with effect on and from the appointed.
Yes, my lord. But before that,
and possession of all private forests in the state of Kerala.
Yes, my lord.
Shall stand transferred to and.
Yes, yes, my lord. But this is not a private forest as far as my case is concerned, my lord. And as far as
these private forests.
My lord,
be identified.
And there is a
definition. Section 2F.
2F, my lord. In relation to 2F1, my lord. In relation to Malabar district referred to in subsection 2 of section 5, the State Reorganization Act 1956.
We are now dealing with the Malabar district area?
Yes, my lord.
Very good. Then read it.
This subclause 1. Any land to which Madras Preservation of Private Forest Act applied immediately before the appointed date, excluding. That is, I am concerned about excluding. And subclause C, my lord. C. Lands which are principally cultivated with cashews or other fruit-bearing trees, or are principally cultivated with any other agricultural crops. My lord, if their case is that it is coming under.
You need to show that at that point of time in 1971, the land was being used for this cultivation.
Yes, that is the first point.
I don't have that evidence.
I have an evidence, my lord. My lord, before that, there is another prerequisite that this land which is coming under Madras Preservation of Private Forest Act, that is a prerequisite. For that, I have appendix 1, my lord. Then kindly come to appendix 1, page number 43. Any land which is under the Madras Preservation of Private Forest Act is only vested under Kerala Private Forest Vesting Act. So, appendix 43, clause 1, section 1. It applies, subclause 2. It applies to private forests in the district of Malabar and South Canara having contiguous area exceeding 100 acres. So, if this property is having a contiguous area exceeding 100 acres,
right, your property might be part of it.
No, that is my case. That is my case. That is my case. That the commission report shows that my property is surrounded by private properties. So it is not a part of contiguous 100 acres land. Then only Kerala Private Forest Act, Vesting Act.
No. There are other clauses also.
Yes, my lord.
One you read out. Then 3 says to private forests situated in other
areas.
Malabar district will be declared. So all of them require a
100
area of
100 acres.
100 acres.
100 acres, contiguous 100 acres. Then only they can be treated it as a private forest under Kerala Private Forest Vesting Act. So I am claiming exemption, my lord, because the notification was issued only in the year 2004 after 30 years of appointed date. Annexure P2 notification.
Someone is appearing against you.
Yes.
So this Madras Preservation of Private Forests Act requires this private forest to be at least of 100 acres.
Your Lordship, may kindly see the finding in page 12. That's the 157 acres was notified. At page 12, your Lordship will get it.
This was under the Madras Act.
Madras Act.
Where do you find it?
Your Lordship will get at page 12, the notification as per which the scheduled property gets it, my Lord. Has been notified as vested forest are specifically averred in the counter exhibit B1 notification is produced.
What is the date of this notification?
This notification, my Lord,
year 2004, my Lord.
2004. Lord, it vested in the government, my Lord, originally by virtue of the statute. Your Lordship has seen section 3. By virtue of the statute.
Under this Madras Preservation of Private Forests Act,
yes,
notification was issued.
No, notification is the.
Under that enactment.
Correct, Lord. That's correct. But then it's automatically vest if it is a private forest without any cultivation.
Of that vintage also, is it not? You can't just wake up in 2004 and say that I am now issuing a notification under the 1949 Act.
No, not a 1949 Act, Lord. This notification.
1971.
Yes, Lord. 2004 notification.
Madras Act, where is the notification?
Ultimately, the question is, not whether it contains 100 acres and more. The fact finding.
At which point of time?
Lord,
before appointing.
How do you date back to 1949?
1940.
And say that in 1949,
yes, Lord.
There were 100 acres of private forest. Yes. In the year 2004,
Lord,
it's still continuing as 100 acres.
My submission is that, my Lord, it's a case where, my Lord, both parties had used evidence. Before the tribunal, even oral evidence and documents were submitted.
What was the evidence available at that point of time? Not in 2004.
Not 2004, because
we are holding against him on the ground that he is not able to prove that in 1971 he was.
Yes, correct, my Lord.
Having cultivation.
That is it.
Cultivating fruits or whatever.
Yes, correct.
Whatever that is mentioned.
But for that also.
Fruit bearing trees or cashew.
Yes.
Agricultural crops.
There is no case for that.
Before we put that onus on him,
yes,
we first need to show us that this act had application.
My Lord, my respectful submission is that by virtue of section 8 of the 1971 Act, the onus lies on him to prove that. Kindly see, Lord, kindly
come to the definition itself.
Yes, ma'am.
Private forest means in relation to the Malabar district.
Yes, ma'am.
Any land to which the Madras Preservation of Private Forests Act apply.
Yes.
Thereafter exclusion.
Yes.
To begin with, you need to show that the Madras Preservation of Private Forests Act did have application.
Yes.
For that, you need to show us that this private forest was of a minimum extent of 100 acres under the 1949 Act, yes, not in 2004.
Yes, Lord, that's
under the 1949 Act. Where is the notification?
Lord, that's a erratum notification was issued accordingly.
So there's no notification before 2004.
Before no erratum notification.
So under the Madras Act, there was no notification at all.
Yes, that will find out, Lord. Some time may be granted, Lord. That will find out because the erratum
state had this act.
Yes,
they would have taken
yes,
steps under this. Where is the question of saying that after it went to now which Kerala, is it?
Yes, ma'am.
Yes.
Now, unless till Kerala came into the picture, there was no notification under the Madras Act.
We will just find out, Lord, because erratum notification was the court tribunal also went under that. The High Court also went under that. Concurrent finding of facts.
How do you put the onus on him without the first initial burden being discharged by you?
Kindly grab the state, not 2 or 3 weeks time to put it on paper.
When it comes to for the state of Kerala, it's some time to ascertain whether there is any notification issued under the Madras Preservation of Private Forests Act 1949, which would indicate as to whether the subject land formed part of a private forest of an area exceeding 100 acres. How much time will it come?
3 weeks.
This strong. (28th of July).
Here the respondent number 4 is expired.
Respondent number 4 expired?
Yes, during the pendency of this petition, my lord, the respondent Yes,
These are more relevant. They have got an interim order.
Let it be said by the head.
Look, they have
deleted,
deleted identical respondents.
Well, they haven't deleted this party. And now while he still remains a party, he died. What is the next step? Please tell us. If suppose a party who remains on the cost item dies,
they are not
do we automatically delete him or do we ask for to be taken?
Put to him if that party is contesting, Lord.
Then either way he'll have to file an application for deletion of the name. One way or the other, you're looking at an adjournment. When it comes to the petitioners, states that respondent number 4 expired and seek some time to take necessary steps. Based on how much time does it want?
2 weeks, once they supply the copy of the certificate, because they have been representing that person.
Do that homework yourself. Now, don't go by order.
It's real
10 a and say that we don't know who applied for the.
My learned friend's client's real sister.
Oh, sister, your own sister, you don't know the LRs.
It's a partition.
Estrangement cannot be to that extent that you even disown your own nephews, nieces, or whoever there is there.
2 weeks time.
We'll give you time. Don't go by order 22 rule 10A and say they've not given me names. Not open to you.
Madam.
This from
We'll find it.
28th of February.
Year of marriage.
People petition with smart.
24. Yeah.
I have a short suggestion. The name to the matter, my lord. This is an issue. I'll just give the background. This is an issue that my predecessor was the member of the society. Other outside predecessor was the member of the society. I have not been admitted as a member because of interstate dispute between the legal heirs. So technically, though I occupy the flat, membership is not conferred upon me. So the suggestion which was given to me, my lord, turns to the impugned judgment.
Yes.
We had suggested that our interstate dispute between the legal heirs may continue. There is no dispute that we are in occupation. Make us a provisional member subject to the outcome of the dispute among the legal heirs. We are continuing occupation and we will settle the matter by paying the amount. We already paid the 50% amount and this can be put an end to. That was a suggestion given on in paragraph 11. Yeah, of the impugned judgment. Mr. Vakil would further submit that respondent number 3 is willing to pay the maintenance charges if he is admitted as the member of the society, and that appears to have been rejected by the society at the relevant time.
But you seem to be disputing the quantum also.
To the quantum, we can, that's not a big difficulty about it. Most of the quantum is on the interest. So 50% you already paid. Balance 50, that can be easily worked out. That doesn't appear to be the main issue.
Maintenance and repair charges.
Yes, the substantial amount is regard to the repair charges, 10 lakhs per flat that was to be given. There are two matters. This can be put an end to it. We are open for that immediately. We can put an.
But you have not resolved your differences interstate.
Interstate differences because the number of people are more. So I don't think that I don't put a quietus immediately as on the day.
They admit as a member.
I'm not even saying no. Only me as a provisional. I'm not even saying you're a provisional for
22. We also said, we also responded to that.
No, but that was I was about to show him, but that's a wrong recording. It was a. If this statement they are abiding by, no difficulty about it. Make us a provisional member, we clear the deal. No difficulty about it. Otherwise, the issue remains to be decided whether without
willing to admit R3 as
but that was exactly the opposite in the court. It's so wrongly recorded.
The only reason for non-payment.
So if they are agreeable to this, we can put a name to it.
But again, I was going to go back and start fighting over the.
Not necessarily. The moment we are provisional member, we'll sit across with my other friend and we'll put an end to it. No difficulty about it.
But they've already said that they're willing to admit.
But actually, it was the reverse. Though it is recorded like this, it was actually the reverse in yeah.
We did not saying that they're willing to admit.
I have taken instruction when I saw that.
We did not apply for speaking 2 minutes. So I take it that this is what it is.
So there was no difficulty with that. So between us, we can sit and easily resolve about the factor.
So there's no point against.
That's correct.
The understanding that
I want to say that absolute membership be given to me. Let it be provisional membership because our interstate disputes continue in the
provisional membership. You are in occupation.
I'm in occupation mode.
Alone.
So with my
are you taking
my family?
No, my lord, I must point out, my lord, insofar as the legal heirs of original member is concerned, a dispute is going on pending in the civil court. My lord, that unless that is resolved, we can't.
No, but this person is in occupation of the.
That there also, my lord, there also, my lord, my instructions were that part of the house, some member occupying because there are 2 flats.
The flat.
Yeah. So, my lord, there is some arrangement which is going on amongst them which we don't know. But
somebody else also is in occupation.
Yes, my lord. Some other member also.
Then you can't say that I will pay for my share of the flat. The other person they need.
So therefore, the provision which says that society can accept whoever they feel that they want to recover from as a provisional member.
No, you'll be paying for the entire.
About it. That was the statement that was made.
Some other
statement made to the. That's the statement in para 11. That should be said. I want a resolution. I don't want to invest. I want you know,
You said hospital and
perhaps we'll be able to solve after 2 weeks, because I think that's a better way rather than getting into legal questions. I fully support that.
Possibility of settlement or before and same time to attempt and make a perception.
Your lordship may not say amicable settlement, a temporary arrangement. So that's not that we are exploring the settlement.
Temporary arrangement, at least for moving forward.
My lords are keeping it after
How much time will it
2 weeks, 2 weeks, or maybe 4 weeks, so that society may require some time. So
28th October.
please, get.
Fine.
Wait, please, minutes.
Yes.
Lords, on the last occasion, I had circulated a short list of dates for the convenience of my lords. That's right.
Is it there? Yes.
Yes, please. Yes, sure. Sorry. So, this is a matter where the learned NCDRC disposed of the petition on 29th May 2023, giving them 1 month time to clear the demand notice which was raised by us, and also then to cancel if they don't within 1 month pay the demand as per the demand notice, cancel the allotments and return their amount with 9% interest. That was the crux of the order of the learned NCDRC. It's against the order, we filed a review petition before the NCDRC, which was also dismissed. Then they came up in appeal before this Honorable Supreme Court. The Honorable Supreme Court dismissed their appeal. After dismissing the appeal, we cancelled the allotment. They dismissed the appeal by the Supreme Court is dismissed on 11th September 23. We cancelled the allotment on 14th September 2023 after giving them due notice. They filed another miscellaneous application before this Honorable Court asking for extension of time. The learned Supreme Court gives liberty if they wish to move an application for extension of time before the learned NCDRC, and the NCDRC to consider it in accordance with law. They move an application for extension of time before the learned NCDRC. Learned NCDRC says give them 1 more month to pay the amount as per the demand notice. Whereas against that they file an execution in which the
the date of that order granting them a month's time?
Please, minutes. That is was 10th
October
2023. Which, in my humble submission, that's the one of the impugned orders. The impugned order, the final order was on 20/12/2023. It was listed repeatedly before the NCDRC and the
20th December is the order. 30 days time is 20th December. Not
yes, yes. 20th December 2023 is the first impugned order before this Honorable Court now. Then they move an application for execution of that order, execution petition before a learned single bench of the learned NCDRC. The learned single bench of the NCDRC says deposit the amount before the NCDRC as per your own calculation, which is the second impugned order, Millards. But that order was passed on 19th of January 2024. So, Millard,
this matter is still pending before the NCDRC.
Yes, Millards.
What happened there?
No, Millards, nothing. It is
because of the
simply
pendency.
adjourned to the pendency. So, Millards, when the first order of 20...
You were required to file a response to the EA. You've not done that. Also.
Yes,
see, directly
we have
deposited the amount with the registry of the NCDRC.
Millards,
you need to
no, Millards, the question before this Honorable Court is whether there was a list before the NCDRC. Once the matter
was decided when.
This
No,
court
no.
granted them liberty to
No,
go
no,
back.
no, but no.
There's no question of you saying that
No,
they
no,
could
no.
not have gone back and asked for.
The learned NCDRC could not have reviewed its own order.
Which order?
The order of 29th May 2023 granting. Manoj, may I just take this honorable court to the order straight away?
There's no question of saying that.
Please, Manoj,
3rd
kindly see.
October,
No, Manoj, kindly see the order.
3rd October 2023, when this court said, let them approach
Manoj,
the
kindly.
NCDRC to ask for extension of time.
No,
Court to have
as
protested that the
we did. We have
in spite of that, if you lost, there's no question of saying that the NCDRC doesn't have jurisdiction. We gave that jurisdiction.
No, Manoj, but I was not heard. Manoj, kindly, may I just give me.
When were you not heard?
Manoj, on when the first time the matter came up before the learned NCDRC asking for extension of time, Manoj, kindly see the order. And
What's your grievance, madam?
Manoj, we have what has happened after 14th September.
What is the challenge to the impugned order?
Yes, Manoj, after
We feel that you are not challenging the grant of time of 30 days. In that sense, order dated 20th December 2023.
that is under challenge.
That was passed in pursuance of the liberty granted by this court.
In accordance with law, Manoj.
Yes.
May I just explain that
Yes.
also, Manoj? Yeah.
What is exactly your
Manoj,
challenge to
now
the
what
order?
has happened is after 14th September, when it was cancelled, third party rights were created, the MOU was signed and property handed over possession. No, Manoj, there was no status.
Did you ask for a review of this 3rd October 2023?
Manoj, there was no, once the order was passed by the Honorable Supreme Court on the 11th of September, both the orders get merged with the order of the Honorable Supreme Court, 29th May and the order of 1st August. Manoj, doctrine of merger applies once the Supreme Court dismissed. Thereafter 3rd October.
Good or bad, that order stands.
That went in accordance with law, Manoj. It says in accordance, they have a liberty. If they move, they have a liberty. Please kindly see the conduct from 2008 till they don't pay any.
Matter is pending before the NCDRC.
No, Manoj, but
the
with due
deposit is directly being made
with
the registry of the
Manoj,
NCDRC.
with due
You are
respect.
asked to appear and enter appearance and.
With due respect, Manoj, the learned single judge sitting in singly could not have passed this order. Could not have passed.
Say it there.
We have said it.
This is just an interim arrangement.
No,
pending your appearance and your filing a
No,
response. That is exactly what the order says.
We have entered appearance, filed our replies, everything is.
Then you
complete.
ask the matter there.
Once the matter has been disposed of by the Honorable Supreme Court, what jurisdiction do they have to undertake?
In accordance with law, which is what you are arguing.
Yes, my
that
lord.
the order is not in accordance with.
No, my lord.
There is an argument that you will advance there, because this is an interim arrangement made in that execution.
May I just make 2-3
You go before the NCDRC.
No, because NCDRC single bench does not have an overriding jurisdiction over the Honorable Supreme Court.
These issues.
No, look, this is
It's in accordance with law, you need to go back.
But
and-
in accordance with law, they cannot go behind the order.
I am for the
Three of them,
intervener.
there are three.
I am for the intervener. We filed an intervention application. We are for the subsequent.
We are not going
No,
to step into the shoes of the NCDRC. Matter is pending there. What all you have to say, go before the NCDRC.
Please have the order sheet dated. Please have the order sheet at page 79, by which their civil appeal was dismissed. This dismissal was in limine.
We have already said the 3rd October 23 order gave them the liberty to reopen proceedings.
That was also in
before the NCDRC.
With order.
Once that is the order passed by this court. There's no question of your.
They don't. They do not.
Once the final
Mr.
decision has
Counsel, 1 minute.
148.
By learned friend,
they don't challenge the cancellation, my lords. They don't challenge the cancellation. They don't challenge the demand.
All that is before the NCDRC, madam, again and again, we are telling you the same thing. That 3rd October order.
Let the learned single judge does, let the learned single.
Sorry, you're appearing.
Will the learned single
Sir,
judge
you're appearing in this.
does not have the authority.
Yeah.
I appear.
You're, both of you are.
Learned single judge.
Different buyers, they've all deposited the entire amount. No. Today. And my lords.
Not today.
No.
Within
Deposited as per
What
their
I mean today
calculation.
was within the time granted by NCDRC.
As per their
The entire amount
calculation
is
now.
Deposited.
Merely because it is in Delhi doesn't mean that every order passed by the NCDRC will immediately be brought.
No, my lords, that's not so.
That is exactly
No,
what
that-
you're doing.
you respect-
Pending before the NCDRC.
With due respect, lords, the.
Sorry, Council. All of you go before the NCDRC.
Madam, we have not even been issued a notice. The order was in our absence.
Whatever it is, go before the NCDRC.
Despite the
and
fact
complain.
that we brought that.
Go and complain before the NCDRC. The NCDRC is still seized of the matter. Matter is alive.
You know,
before the
in an
NCDRC. We are not going to.
You know, that's why, you know, it is only the
Only the
execution.
execution is there.
But if you all speak, you will not. hear.
Sorry, Council.
One
You're not
minute.
interfering.
Milord, may I just make this position very clear, Milord? It is only in an execution petition which is pending there, not the petition on merits. Now, in an execution
This earlier order dated 20th December was passed in which proceeding?
by in an application which asking for extension that
Where
will be
is
for.
that application?
Please, Milord, may I have that application is before on page on the page 1991.
So that
Milord, that is at 116, Milords.
MA is disposed of.
Yes, that MA is disposed of.
Demanded amount with up-to-date interest 9%.
But yes, Milords. So, Milord, that MA is disposed of. Now there is only an execution pending. Now, in an execution, all these issues
This
cannot
order
be.
was passed in your presence? Yes.
No, Milord, yes, it is passed in my presence.
Okay.
Yes, Milord.
There's no
What
question
I'm,
what you're saying that-
no, it's passed in my presence.
It
But
was.
what my humble submission in Milords, at the moment, there is only an execution petition pending. And that execution petition, the court cannot go into all these aspects. With due respect, that's my humble submission. That they cannot in an execution
This order was passed on 20th
of
December.
December. Please, Milords. Against that order,
And you did not come here till
no,
March.
Milords, I came in, yes, I came in March. And within my.
By which time the execution application was filed?
And the order in the execution petition is just 2 lines to say, deposit the amount as per your calculation and with the registry of the NCDRC. Well, had that been the occasion, the learned division bench of NCDRC would have thought about, or had asked them to do it. The earlier order of the 29th May order clearly says, with 1 month time given, despite that we gave them 9 weeks, 1 month was to be given, we gave them 9 weeks to deposit the amount. Since 2008, they have not deposited. They are defaulters since 2008. And
When did they deposit the amount pursuant to this
Between
19th
19th and
December?
22nd January 2024.
Between
Between 19th and 22nd January.
2024 minutes. This minute, and kindly see the profile of the three
Within a month.
respondents. Minute, in an execution petition.
January 24.
Some of you may have exceeded me.
No, all of us.
All
we
three
have.
within that time. All
It is 30 days from the date of this order,
But
not from the
within-
date of receipt. So the 30 days started ticking from 20th December 23 itself. So 21st December we take it, date of the order excluded.
Yes.
So by 21st of January you had completed?
Yes, this
Yes,
has
yes.
been deposited.
We
Yes, my
have
lord.
charts for all
We
of
have
us
a chart
with
for
the
those
dates.
deposits with
So
the
your
dates,
lordships
yes.
can see that.
And that is the amount this honorable, that order said demanded amount.
Give them.
The learned executing court judge, it says as per your own calculations. Minute amending the order.
January 24.
Just see the second page, please.
This is
Serial number 12 and then serial number 14.
Yes.
11 is the order, my lords. That's 20th December 23. Serial number 11. Serial number 12, this is the date of offer of full payment including interest by us. That is within 8 days. We offer it.
Demanded amount though.
Yes. We
Also
offer.
demanded.
Correct. This is the amount. This is the amount that is due from us along with interest.
Not as per your calculation.
But they did not.
Initial order said
That's not correct.
deposit
Correct. So the first,
the demanded amount.
so the first order required them to, within a period of 4 weeks, provide a calculation sheet where there is the amount due from them to us and the amount due from us to them. No.
This order, 19th
Correct.
December.
Yes. Your Lordship
20th December.
impugned judgment.
20th December says
Correct.
you will deposit the demanded amount.
Correct.
So what exactly is the demanded amount as per this order?
Your Lordship will have to go back to the order of 29th May 23, which is the main order of the NCDRC in the appeal, at page 59, where is the main principal directions of the NCDRC. Same brief.
But page 61 is
At
the
page
demand notice,
60
which is the
the
demand
order.
amount.
60 is the order. Your Lordship have it?
61 is the demand?
Demand
Page
notice.
60, page 60.
Yes.
Page 60, order. In view of aforesaid discussions, complaint is partly allowed. Opposite party one, that's them, is directed to issue fresh statement of account. This has not been done till date. Fresh statement of account, charging interest at 9% per annum on the balance amount payable by the complainants on after 12/1/16 and giving, please.
Yes. This order, 20th December.
That's in our MA.
Ends with the demanded amount.
Correct.
In the body of the order, is there any mention of how this demanded amount is to be worked out?
No, one has to go back because the MA is in the main appeal, which is the order I was showing your Lordship. The operator part is page 60. So because
they were required to revise their demand and give you a demand.
Correct. Because of what I was just reading, which is and giving delay compensation till 11/1/16. This is the 2006 booking, my lords, of our apartments, which we haven't got till today. So 19 years we waited for our apartments. They had to deduct their delay compensation due to us, make the entire calculation sheet.
This is the order dated 29th May.
Milord's 29th May order. Wait, Milord's,
That's the principal judgment in the appeal.
We
Now, there are 3 timelines provided in that. Just 1 minute, Mr. Singh. There are 3 timelines provided in that order. The first is the calculation sheet after deducting the delay compensation that they have to pay to us, which has not come till date. Not a penny has come. No compensation deduction has been made.
No demand is also issued after this order.
There is. So I just want you to, Lordship,
Page
just see.
61. 61 to 63 is the demand
Within 1
notice
month
issued to them.
Yeah.
After the order of the learned NCDRC.
This
at the same.
Oh, I'm sorry.
If I can, I just want to unclutter this. There are 3 stages.
Yes.
First, 1 month for calculation sheet, adjusting both what is due. Second, 1 month is for us to deposit the amount. The third is a 6-week period where they will execute a sale deed to us. So these 3 stages follow one after the other.
Yes.
61, they claim, is their discharge of that first obligation of 4-month calculation sheet. If you take a look at this, you will not find any delay compensation paid to us, which is what was directed by the NCDRC. So today, if your Lordship's answer is there a demand notice? There is a demand notice that I cannot run away with. But does that demand notice in terms of the appeal order against which has become final, is there a calculation of their delay compensation to me? No. Therefore, I'm left with the option of paying what my balance is with interest to them, which I tendered within 8 days, which they didn't accept. So I went back to the NCDRC. No, I'm sorry. I'm sorry. I went back because serial number 11 is where I tendered the offer to them. In that sheet I handed up, I'm sorry.
Serial number 11.
Serial number 11 is the order. So serial number 12 is where I offer the full payment including interest. That is as per my calculation. Serial number 13 is the execution petition. 14 is where the deposit is made because they refuse. They refuse to accept the payment. I am pushed to 22nd January 24. Otherwise, the payment was tendered within 8 days. That is where we stand now.
May I please speak? May I just take my loss to the NCDRC order at page 47?
47. What is that order?
NCDRC 29th May order.
Yes.
The learned court records right from paragraph 3 onwards their default demand notices, and may kindly see paragraph 3.
After all that, the concluding paragraph.
Yes, what I was pointing out, my learned friend is saying delayed compensation has not been adjusted. It has been adjusted. It has been recorded. So, kindly see at in the order at page 47. May kindly see may kindly see in this where they say that the builder has adjusted the delayed amount and then paid. We have paid the amount.
That is not what the concluding paragraphs.
No, Minutes, kindly see the middle of the paragraph.
NCDRC found that you had already adjusted it. You could not have said give delay compensation.
Kindly see, Minutes, in the middle of the paragraph, the builder wide letter dated. Minutes, I'm sorry, but it's in the 15th line in the middle of paragraph.
11/6/2013.
The builder wide letter dated 14/1/12 formed that after adjusting the delayed compensation payable up to so and so and a sum of 37.
But this won't do because the final order is that you will give delayed compensation till 11th January 2016. So if you have given it up to 2011, you still need to give 12, 13, 14.
But Minutes, they did not challenge the demand notice. I was asked.
This order has attained finality.
Yes, Minutes.
Now, in terms of this, you have to adjust the delay compensation.
We had
11th January.
We had done it, Minutes.
2016.
Yes.
Where is it reflected in your demand notice at page 61 that you have adjusted?
This order attained finality when the honorable.
Yeah, asking you a simple question, madam.
Yes, Minutes.
Answer.
This
11th January 2016.
Yes.
Where do we find the delay compensation adjusted?
11th January 2016.
Which is what the NCDRC orders at page 16.
Yes, sir. The was offered possession and Minute.
No mention of delay compensation here in this notice at all.
May I just go through the calculation and show that from this is may kindly see the note at page 65. Page 65 Minutes. When I did the note after the chart, as per order dated 29th May 23, passed by the NC, you have to deposit the amount of so and so, which includes 9% interest, which is the balance amount payable after adjustment of delay compensation, as mentioned in the statement of account.
Statement of account attached.
This is the one. This is the statement.
Where is
Annexure A, Minutes, page 66.
Where do we find the
page 66 Minutes.
Minutes,
interest on delayed payment. Minutes, may kindly see G Minutes. That is the interest on delayed payment, if any. Then we adjust this amount.
Where is it? G. Interest on delayed payment.
Yes, Minutes.
Delayed payment is
that's what they're charging us. That's our interest on delay.
Delay compensation is what is mentioned.
Well, that was after adjusting. Then there was a
You say that the details are there. Statement of account attached. Where is the statement of account?
No, this is
showing the delay compensation. Whether you have
I'll place
adjusted it till 11th January.
No, I will place that because that document
this is the statement of accounts.
No, this was sent. This was sent to them in June 2020.
All this you go before the NCDRC.
No, the NCDRC in executing court does not have the
because you did not act by the looks of it.
No,
we have. If you are able to demonstrate it, we will also make note of that. We will make
give me
note
one,
of that.
one
We are not going to step into the shoes
No,
of the NCDRC.
the learned
Hear the order, thereafter you can mention.
No, the learned, may I just make
one thing that page 66, the same calculation sheet which was being shown. Please see the mischief just below that signature.
Yes.
Below the signature on page 66. Discount and nature of compensation for delay as per the contract.
Where is it?
Just below the signature at 66, middle of 66. Yes. Below the signature. Discount and nature of compensation for delay as per the contract and as further agreed upon so and so, out of which
it has been adjusted.
nil has already been paid, adjusted, and balance will be adjusted. These details, if required, shall be provided by our executive during your visit.
So, here also you say the balance shall be adjusted, not
yes.
May I
and why should it be during? Why should it be a visit? Why should I go to
my learned
put it in writing?
Hold on for a minute.
Not how it is.
No,
Order. Page 29 does not say that you will first take the amount due from them and then pay them the delay compensation.
May I just make this honorable court has to see, my learned friend will give you 1 minute. This learned friend, this honorable court has to see the conduct.
We are not going to
due respect, 2008 onwards,
My lords,
they have not paid a
No.
single penny.
Before my lords passes that order, there's just one submission that I made. That on 3rd October 23, this court granted me the liberty to go back. I went back seeking that extension of time to deposit that amount, which is what NCDRC gave me. My lords, I'm also on a simple principle, apart from the merits and all that have been placed. My lords, under section 148 CPC, my lords have held consistently down the line that if there was a power with the court to fix a time to make that payment, then there is also power with that court to extend that particular time. Now, NCDRC, being a court, as has been already held, has done nothing but to grant that extension of time. And that order of 3rd October, more particularly of this court, granting me that liberty to go back and seek that extension, has now worked itself out by NCDRC acting completely within its jurisdiction under section 148 CPC. So, my lords, today...
This argument also you can advance.
No, my lords, that stage, my lords, that part out there, that order directing me to deposit, and I have since deposited that amount. It's their failure to give that particular
We are not
statement.
going to go into the merits of the matter, Mr. Gordon.
My lords, in fact,
We are going to leave all it is open. Whatever you need to say, you go before the NCDRC. You are subsequent purchases.
Yes, my
My lords, there...
No, it's shocking that when we filed our appeal within that 4-week period, they suddenly went and sold it
That's
without sending us a calculation.
Attain finality after the Supreme Court.
Wait 18 years.
No.
One small
2008, you don't pay a single penny from 2008.
small submission and
Don't
what
pay.
has happened.
My lords,
Whatever issues you have, you please place it before the NCDRC.
These issues cannot be taken up.
After the
Then they have a separate complaint against you.
No,
When the matter is pending, how do you sell it to someone else?
the matter is not pending. That's September, the matter was.
When did you sell the
I'm
apartment?
saying 23rd of September 2023, this Honorable Supreme Court dismissed their appeal on 11th of September. It was the closure of the matter. 14th, we cancelled their allotments. 23rd, look, I'm a binder. I need funds to continue with complete this. They don't pay since 2008.
So we have this specially petition. The two companies, is it? Shipra Estate Limited and Jai Krishnan Estate Developers.
Yes, ma'am.
It's a company or two companies?
It's the partnership formula. Yes.
They're both opposite parties.
It's not a corporate.
No.
No, it'll be
to estate.
the JV.
The orders.
Both are
12/2020.
One will be landowner, one will be the.
And 19/1/2024.
I see.
Passed by the NCDRC. National Commission. The first order, dated 20/12/2024, was passed in execution of 510 of 2023. In consumer complaint number so and so. 510 and 519. In consumer complaint numbers so and so. 511, 512. Yes. While the subsequent order dated 19/1/2024 was passed in PA numbers so and so in consumer complaints numbers so and so respectively. The matter, the execution applications are still pending consideration before the NCDRC. The result of the report reflects that the national NCDRC has order dated 29/5/2023 in consumer case number 3689 of 2017. And the concluding paragraph thereof reads as follows. This is at page 60. The petitioner firm claims to have issued demand notices pursuant to the stated dated 29/5/2023 on 19/6/2023. Insofar as the issue of delay compensation till 11/1/2016 is concerned, we find that
At page 65, something was shown to us.
That's the so-called calculation sheet in a reminder to the demand notice.
As per the order which is after adjustment, we find that the following note was appended in the demand notice. Para 65, sorry, page 65, the note. This. Full stop. The attached statement of account, however, contained another note which reads as under. The aforestated notes demonstrate that the delay compensation was not adjusted as against the demanded amount and was to be adjusted in future as indicated by the use of the phrase single inverted commas, balance shall be adjusted. This was not in keeping with the direction of the NCDRC, the concluding paragraph of this order dated 29/5/2020. It appears that the petitioners in the consumer case thereupon approached this court. This order was passed, the SLP was in relation to the 29/5.
Yes, Manoj.
Yes, yes. In fact, that
it may be noted that this court confirms
that the chart
stated order dated 29.
the chart has all the dates.
And 1st August 2020. Normally, there were two orders, the review one.
Especially petition.
It was a civil
Appeal, is it?
Appeal.
By dismissing the appeal arising therefrom on 11/9/23.
Yes.
Yes, yes.
On 11/9/23.
This was against both the review and the main principal order. We had filed a review against this.
Review was also there.
This review was also.
It appears that there was also a review filed in relation to the aforestated order dated 29/5/2023, which came to be dismissed
On 1/8/2023.
on
1/8/2023. Serial number 5.
Both the orders, both the aforestated orders were subjected to challenge before this court in civil appeal number.
It's a series of civil numbers. 5, 7, 9.
In a batch of civil appeals which came to be dismissed on 11/9/2020.
After which the MA in the Supreme Court, where that order came.
After the issuance of the demand notices, the petitioners in the consumer case approached this court by way of miscellaneous application, seeking extension of time to make the deposit. The said application was disposed on 20th 2023.
It was withdrawn.
2012.
No, it was
No,
withdrawn.
310. Sorry,
310.
Yes.
On 3/10/2023. With liberty was given to the applicants to move such an application for the NCDRC. And in the event such an application was filed, the NCDRC was directed to consider the same and pass it 48 orders in accordance with law. It is pursuant to this liberty that the petitioners filed MAs before the NCDRC, resulting in order dated 20/12/2023. By the said order, the NCDRC directed as follows, is at page 8. Full stop. As the initial demand notices issued by the petitioner firm pursuant to the order dated 29/5/2023 were not in keeping with the directive therein, as already noticed here and above, the
99.
applicants appear to have offered the amount due and payable by them as per their own calculation, which was refused by the petitioner firm. Agreed thereby, they filed execution petitions before the NCDRC, wherein the subsequent impugn order dated 19/1/2024 came to be passed. This order required the applicants in the execution applications to deposit the amount payable by them as per their own calculations with the registry of the NCDRC. By the very same order, the NCDRC directed issuance of notice to the judgment debtors in all the cases, giving them 4 weeks' time to file their responses. However, you have not filed a response.
We have filed a response.
The petitioner claims to have filed its responses in the apostated execution applications. But due to the pendency of this matter on the file of this court, the NCDRC seems to have kept the execution applications pending.
We have made our payments on 19th and 22nd in terms of the second dispute order.
That the deposits in terms of the apostated order dated 19/1/2024 were made on
19th January 24 and 22nd January 24 on behalf of the private respondent.
Not 19 January, 2012 and 23 were made on between 19th and
22nd January
2024. In any event,
My lords, may kindly report the fact that it was cancelled, their allotment was cancelled on 14th September, and this is a fact.
Counsel for the petitioner firm would assert that the allotment of the flats in favor of the applicants was cancelled on
the 14th of September
2024.
And 23 minutes.
23
minutes, and this is a fact which they mentioned before in the application of extension of time which they filed before the NCDRC and in the Supreme Court. So due respect.
However, given the aforestated facts and circumstances, and as the matter is still pending consideration before the NCDRC, we are of the opinion that interference by this court is not warranted at this stage in a special leave petition.
Civil appeal.
Pending for a single judge.
This is
special leave.
Especially.
With due respect, this is pending.
It is, we are further informed that pursuant to the cancellation of the allotment of the petitioner firm went ahead and sold the very same flats.
They have only entered into MOUs. Only
MOU. Possession has been given.
My lords, MOUs. They have
Amounts have been paid.
Entered into transactions with third parties for sale of the very same flats.
Which is taken note of by the NCDRC at page 8. They say, they have noted this fact, para 12. Para 12, bottom of page 7. They say it's pendant right, so it will.
As we accordingly dismiss the special leave petition, leaving it open to the parties to address all issues.
With due respect,
The third parties who seek to be impeded, who filed applications seeking to be impeded before this court, are at liberty to move similar applications before the NCDRC and advance their stand.
Well, I'm sorry, that last sentence, because of the observation made by the NCDRC, just see that observation at page 7. They have not filed a substantive SLP against this order. The third party. But your observation will strengthen their hands with the NCDRC. Let them try their luck with whatever they have to. Page 7, bottom para 12. So far as creation of third party right is concerned,
we have not examined the merits of the claims put forward by the said third parties, and that issue is also left open to be addressed by the NCDRC.
May I make a submission? This is a matter pending before the executing court. Before the executing
MA order, we also make it clear that so far as the order dated 2012-2023 is concerned, passed in the miscellaneous applications is concerned, we find no grounds to interfere with the same as the
My lord, that will kill, that will,
No,
that
the
will,
whole purpose.
that will close my rights, my
You
lord.
know, that order.
My lord, that will close my rights because this was disclosed.
You know, that
This
the
was
whole
disclosed on the
purpose.
first day.
Petitioner firm failed to issue demand notices in terms of
No.
the said order.
But this
My
issue
lords, we
needs to
kindly
be looked into.
Can't again be
It cannot be reheard. This matter cannot be
Paid money,
reheard.
I still haven't got my
The
flats
Honorable
after
Supreme
19
Court
years.
has dismissed their petitions. It cannot be reheard again. Otherwise, there's never an end to litigation.
My lords, may I respectfully
Failed to issue demand notices in terms of the direction in the order dated 29/5/2023, in relation to which 1 month extension was granted.
My lords,
We give liberty to adjournments to
My
let the
lords.
NCDRC look into the demand notices
My lords.
because with the
All issues we said.
it could not be seen by the executing
My
court.
lords,
We are not going to say anything.
But
My
when
lords.
this is before the executing court, they do not have the jurisdiction to go into
Whatever
the
issue you
merits.
wish to raise, you want to file fresh complaint cases, you file it also.
No, my lords, in
After
fact,
so many years, Milad, they have defaulted, Milad.
You have been nothing short of.
No, Milad, 2008 onwards, they have not paid a single amount.
This note which you attach to that.
No, but this is subsequent. Milad, kindly.
That
Milad,
shows you an act of bona fide.
No, Milad, my lord has to see their bona fide.
Directed you to pay delay compensation.
We have done it. We have adjusted all of it.
You have not adjusted it. Say that it will be adjusted. It shall be adjusted.
No, we will demonstrate that.
That clearly
We
indicates.
will
an act of
demonstrate
bona
that.
fide.
Milad, we have adjusted.
Want us to make a comment
No,
about
Milad,
that also? Then it also.
But Milad, this their conduct.
If you argue further, then we will be constrained to observe something about your conduct.
Obliged, Milad.
Yes, next one.
Yes.
26.
There is a duplication of reporting the vacancy. We have 2 vacancies reported. That is why this situation happened. Now, BSc filed a counter also because there is a direction.
It's only a compensatory order, my lords, because of the illegality committed.
So, 2000 notification,
Yes, my lords.
rank list of 2012,
True.
This is
2016 OA, allowed in 2020, and we are now in 2020.
It's a fact.
And this lady is still waiting for an
Yes.
appointment, or you've given her an appointment?
No, my lords, I am for the lady.
You are for the lady.
I am
She's
for
being
the
given or she's not being given?
No, she's not being given.
She's
She's
still not
first rank holder.
You don't report vacancies.
Yes, no. In fact, big vacancy report, but there is a duplication.
Then
That's-
perhaps it's,
Yes, I
dismiss.
yes, please, because
You can't
High
take
Court-
someone.
I
What
understand.
kind of recruitments do you undertake? Mr. Nair again. KPSC.
This time totally no, non-adversarial.
KPSC.
Wrong reporting. If not.
No, but what kind of recruitments are these? 2000 notification, 2012 rank list, 12 years.
No, there are-
This is for a lecturer's vacancy.
Arabic college.
Arabic.
Teacher.
That also part-time.
Part-time teacher, poor lady.
This is rank list is 2017, Lord, that extension. We'll also then.
We'll just dismiss it. Having heard the long come for the parties and upon everything, the judgment passed by the Kerala High Court, we find no grounds to the income judgment, especially petitions accordingly dismissed. The petitioners shall take steps expeditiously to provide appointment to respondent number 1.
Obliged.
It's again 2012. So
Lord, I just request one thing, my lord. I want to, my lord, place for 10 minutes, my lord, certain facts which, my lord, will, my lord, possibly show there is some
all
confusion.
your documents say 2000.
Lord, that's why I'm requesting. No, Lord, that's not. There are 2 things. Lord, I think there is something which we are missing completely, and that's probably our fault. And that's what I wanted to start with. Lord, kindly see 239, because, Lord, the gamut of the entire, my lord, scheme of Surfacey will turn on its head. The problem is that. And my lord,
don't take care with your.
no, my lord, 2 things. Lordship asked us to give. My lord, I'll request, my lord, because these interventions will not, my lord, help anyone.
He's already facing an uphill task, Mr. Rao. Why do you want to make it more difficult by putting stumbling blocks?
Yes.
2,
There are two things, 239.
Yes.
My Lord, before your Lordship see that, two aspects, my Lordship may bear in mind. Lordships have put to me that we didn't take care. Now, my Lord, I'm sure Lordships in the course when your Lordships issued notice and the other banks are not even parties. The Lordships may bear in mind. Lordships asked us those documents. Those documents have revealed that what the High Court has said is not completely correct. My Lord, I did not invite this factual, my Lord, inquisitiveness. It was a writ petition filed contrary to your Lordship's repeated judgments that you must go under Surfacey 1. And therefore, my Lord, the least which can be done is that at least the documents which are there and where the factual error has happened will have to be shown to your Lordships. Now, my Lord, having said that, 239, if your Lordships were to see, this is the 13-2 notice, my Lord. We, IARC, as trustee of IARC, so and so, hereby issue you notice electrics in the capacity of borrower mortgager at the address mentioned herein above under section 13.2 of the Surfacey Act on behalf of, now Lordships may note this, it is not just on behalf of the petitioner. The notice is on behalf of all secured creditors. There is no dispute with regard to the entire mortgage as far as all secured creditors are concerned. Canara Bank, IDBI, United Western Bank, but I'm at 240. Industrial Development Bank, since assigned to Kotak, Bank of Maharashtra, Commercial, SBI, Commercial and International Bank, since merged with SBI.
All of them have mortgage documents?
Yes, undisputed.
I have also.
And the entire one.
All of them mention the.
There is no dispute with that.
There's no dispute.
That is what I was trying to tell your Lordships. And my Lord, here also I will convince your Lordships that the very documents in the schedule are showing something else by mistake.
Only this one. Which one is it?
IARC.
IARC.
And that's all also I am clarifying your Lordships. The very documents which have been put against me, the body of it has.
IFCI has a document which says only 2000.
That's what I'm trying to say. The schedule says 2012. The body of the document is saying 1 hectare 2012. And ROC registration is also.
The point that you are now making is that the other secured creditors who have independent mortgage documents.
Yes.
Those documents mention the full extent of 1.
Yes, that was placed before High Court also, and that's why we said that under 13.9, and that's why I want to show to your Lordship. My Lord, my apologies that I'll have to show the provision first rather than going, if we can have the surface. My Lord, kindly see 13.9 for a moment. Section 13.9 of the Surfacey Act. And my Lord, I'll also, my Lord, tell you, I'm, my Lord, also concerned.
Now, why is it that you are the only one before us?
Yes, because nobody else was brought on notice, my Lord. And we told the High Court there is an application filed for bringing them on a record. My Lord, kindly see 13.9. Lordships have section 13.9 of Surfacey Act, your Lordships. And my Lord, I must dispel this notion that the documents are only saying 2012. They are not. The Lordship may take it, I have checked up. Even in IFCI, it's 1 hectare, and Lordships rightly wanted IFCI, my assigner, to place those documents. They placed certain documents where the original ROC is showing the first loan of 3 crores, the entire mortgage is for 1 hectare, undisputedly. So there's one 2012, my Lord, let me be here, sir. And only in one MOE, my Lord, this error has occurred. One MOE, and that too in the body of the MOE is 1 hectare 2012. Now, my Lord, having said, kindly see 13.9. Subject to the provisions of IBC in the case of financing of a financial asset by more, my Lord, 13.9, section 13.9, Surfacey Act. I'm sorry, my Lord,
What's the Surfacey Act we're looking at?
Section 13, subsection 9. 13, subsection.
I'm looking at 39.
No, my Lord, my 13, subsection 9.
Yes.
Lordships have that? And subject to the provisions of the IBC in the case of financing of a financial asset by more than one secured creditors or joint financing of a financial asset by secured creditors, no secured creditor shall be entitled to exercise any or all of the rights conferred on him under or pursuant to subsection 4 unless exercise of such right is agreed upon by the secured creditors representing not less than 60% in value of the amount outstanding as on record date, and such action shall be binding on all secured creditors. So therefore, my lord, today to set it aside, and which was not even the prayer. The prayer was that the section 14 magisterial order, which is based on 13.2. And that's why your lordships have repeatedly said that if you have any grievance in matters arising from Surfacey, please, you will have to go and appeal. And that, in fact, lordships have castigated the high courts in many occasions, unfortunately, to not, my lord, follow that. Now, having said that, my lord, what is troubling your lordships, my lord, is that there are some rights which are claimed by buyers. My lord, I have repeatedly said that the two, my lord, entities who actually are the borrowers and then the borrowers selling, they are, my lord, evading this notice from here, and one of the borrower, my lord, the entity who has actually taken it first and then acted as a confirming party is not even a party. I could, my lord, work out probably that if they come and if they at least put their stand, it could be some reasonable way. And my lord, I must state this notion that, my lord, the final buyers are also completely innocent is also not, my lord, proper, because kindly see the agreement itself. Lord, these are the buyers who went, my lord, to when the possession was being taken. That we are. That's right, my lord. Lord, in that respect, kindly see for a moment, and then I'll, my lord, tell if we could work out a solution, my lord, if it pleases your lordship. Kindly see, my lord, that paragraph in the agreement, which your lordships would find.
First, tell us which respondents are the.
All are buyers, my lord.
All of them.
All are. They were the ones who went to the writ petition. That's the problem. They purchased it from this entity. The borrower, my lord, has not disputed any of these transactions, and rightly, in fact, in section 10, he admits that I have so much loan. He's been declared insolvent, my lord, during the pendency earlier by the Bombay High Court. And yet he, my lord, signs all documents and does this exercise contrary to the mortgages. Keeps the banks in dark.
So now we have the subsequent purchasers only.
That's right. So therefore, kindly see
Electrics is not a party.
They are party not coming, and my lord, the person who has given it in their favor, Bindu, actually we have that they are not party at all. So I was suggesting two things, my lord.
Who is Bindu now?
Bindu, my lord. Bindu. So, my lord, may I just hand this chart because it will make it easier for your lordships to appreciate what I am saying.
Yeah, copy.
Yes,
Same. You are for Kotak, Mr.
Yes, fellows, I am for Kotak. So, in fact, we have filed an.
Your lordships, kindly oblige by keeping 281 besides you when your lordships are going through this chart for a moment. I'm grateful.
Page 280.
Yes, sir. (281) is the memorandum, my lord, at page number. This is the supplementary one. Yes, my lord, kindly take 287. I showed 281 because the document starts there. This is the agreement which the borrower does with this third party Bindu. Now kindly see, my lord, 2.2. And then I'll take your lordships to the flow chart. That the request of the vendor, lordships have that, my lord? That on the request of the vendor company, the purchaser covenants to pay further advance amount from out of the sale consideration towards the discharge of existing loans availed with several banks. The further advance amount hereby agreed to pay to the purchaser to the vendor company after the fulfillment of the condition referred under 2.1 supra. That after the release of the loan, the vendor company shall furnish the discharge receipts along with NOC from the banks. Now, my lord, first and foremost, this agreement itself was illegal because banks were never informed about this agreement. Lordship knows when there is a mortgage existing with so many banks, you cannot enter into a transaction. Yet this transaction is entered. But they do provide for this clause. Now, my lord, surprisingly, all these people who have bought have not at all gone into the aspect of these clauses and they say that we are, my lord, purchased it and we are innocent. Now, having, my lord, even if we give that liberty today, at least Bindu must come here and explain on what basis they entered and sold this property. The actual persons who have created this mess are evading your lordships, and the banks are, my lord, with 896 crores of loan of public funds are going to be, my lord, put to. And of course, if they are genuine, Though, my lord, this clause shows that precaution, and your lordships are aware, 13.2 notice is in public domain. Everything is, my lord, advertised. The possession constructively under 13.4 is taken much before. All these aspects are well known in public domain. So it is not one and ROC. ROC, my lord, registrations initially show that 1 hectare 2012 for all these banks is existing in ROC record. So when you are dealing with a company from whom you have purchased, that is the basic, my lord, due diligence which anybody would do. Now to, my lord, and all of them, most of them in fact, when possession under 14 was sought to be taken, they gave letters saying we will give the possession undertakings to the magistrate court, subject to correction. And then, my lord, they went and filed this writ, and writ, my lord, all these factual aspects are ignored. And 13.2, which was not even challenged, the final outcome is that 13.2 notice.
For the High Court.
My lord, we did. My lord, that's the problem, because High Court only went. My lord, that is the confusion, that the High Court only went with my assignment deed, forgetting that the assignment deed.
Why did you not produce the other banks' mortgage deeds?
Well, this is the difficult. They were not. In fact, nobody was.
In fact, we have filed an application saying please implead, because there are 9 banks. There were 13 banks. I have assignment from 6 Millers. Kotak has assignment from 6 banks.
Even today, there are multiple banks. Canara Bank is also there. They have an OA which is showing 1 hectare 2012. Admittedly, OA has decided, and a recovery certificate, my recovery certificate, you can have a problem with saying, but Canara Bank also has the same recovery certificate.
Your mortgage deed mentioned.
Yes, Milos, I have flagged it. Milos. In my volume, I have flagged all 4 pages. Milos.
You filed a
separate SLP with permission. Yes,
my lord, they have moved. Before intervention, I am giving a solution.
Kotak Bank was never.
Because they were not made
parties.
Now I am trying to work a solution, my lord, if my learned friends were. My lord, probably. My lord, probably. I don't know whether it will work or not, my lord. I'm just.
Want them to pay.
No, my lord. That's obviously finally, that's, my lord, this litigation will not end, because, my lord, banks have taken finally, the loans are now running under 890. But he is wound up. He was insolvent when he has signed these agreements. By Bombay High Court declared, and all those transactions are already held illegal by Bombay High Court. No, Bindu probably is there. That's why I am, my lord, beseeching your lordships at our request. Kindly have Bindu made a party and let them file a reply to explain how they entered. Probably, my lord, if they come, some money can be revived back and we can consider.
Where is that description of Bindu?
Yes, my lord. Now, my lord, if your lordships, the agreement which your lordship was seeing first at 281.
Forward, what is the solution?
My lord, what we have, my lord, thought is that some money probably will get recovered. And then, my lord, the banks could at least work out what is there. Because finally,
going to be.
My lord, I am only placing, there are 2 ways, my lord. I can place the legal point that 13.9 notices covers everything. Therefore, the High Court in a writ jurisdiction ought not to have gone into this factual aspect. And I am yet to show even the documents which have been held against me are itself in the body showing 1 hectare 2012. So that is not considered by the Honorable High Court.
Schedule shows 2000.
The schedule is making the mistake. And the High Court has also missed the point that after subsequently, and my lord, my learned friends are, my lord, saying my assignment deed is only saying a particular. My lord, before your lordship put.
Mr. Rahul.
Please, my lords.
We will only set aside these orders on the ground that the writ petition ought not to have been entertained, given the number of disputed questions of fact. It is for you to go before the.
Something to say. You may just give us
Every coverage tribunal before it and make out whatever case.
Can I just?
You did not invoke section 17 at all. Did you?
No, but I have one submission.
Writ petition would not.
My lords, just one. It's one. There are consistent series of documents.
There are documents of the other banks.
From the, my lords, right from the beginning, they only record 2012. My learned friend, my learned friend has not shown anything. Can I just?
Apart from IFCI,
Yeah.
have you checked the other banks' mortgage documents?
Let them check, my lord. We are open for them to see it. I offer it.
Check and see and tell us.
They have never.
Other banks have mortgage.
My lords, but no one has come forward and.
Kotak Mahindra is before us now.
My lords.
One is enough.
My lords, today.
One bank is enough. Show us your mortgage.
Yes, please have.
My lords, Kotak must take its own proceeding. Kotak can't start a proceeding halfway through.
May I just say
This document shows 1 hectare in 2012.
My lords, can I?
That is enough for us to set aside this order.
No, they may be.
On the ground that.
My
What's the mortgage deed?
My lords, can I just show one thing, please? Here.
One of my district.
My lords,
Lordship will have all 4 volumes and it.
can I say one thing? If
Let us first see the mortgage deed.
If the
First see it, there are.
first you see the IFCI mortgage deed. Otherwise, may see the IFCI mortgage.
This is Canara Bank, I have mine
my
also.
lord, page 38 of this Canara Bank, please see the recovery certificate itself.
It was never given.
It was never a part of the record.
Sir, but 13-2 notices for all banks. My learned friend is not right by saying banks did not come.
Mortgage deed is not there.
It's there. I'm just asking the court
Never.
to take it out. That's not there.
Never.
It's there.
It's never been a part of the record.
Because can I indicate, I am not a party before the High Court. I can't file anything which is not there. If my learned friends don't make me a party, I can never produce my deeds.
Let us see.
Yes, so therefore I'm requesting the court master to take it out. There are 4 volumes in my SLP. It's annexure P51, which says application for permission to file additional documents.
And in this, what do we have?
But this is the Canara Bank where I am now producing the OA, which is a recovery certificate, which is passed by the DRT. That itself is showing that. Wait, my lord, I just took out that.
Lords, may I make one submission for your consideration?
See these documents. There are
Apart. So far as this present petitioner, which is Mr. Dave's client, is concerned, there is an assignment document, and that assignment document records 200.
There is no getting away from the fact that
I am not on that.
demand notice. It's not on behalf of only IFCI. It is on behalf of all those banks.
My lords, may I?
All those banks have separate documents.
My lords,
If those documents show that the security interest was created in 1 hectare, 2012 square meters, your claim before the High Court in the writ petition that IFCI's document covers.
my learned friend says that there is no separate assignment deed by from any of the other banks that would have been IFCI. No, my lord.
32 demand notice itself.
My lord, I am on that. I am
In fact, you yourself made a point of saying that IFCI's assignment deed also mentions only 2012.
I am on just.
So where is the question of just saying there's no assignment deed?
My lord, it's assignment deed only for my learned friend, Mr. Dave's client.
Please look at the
Not-
32.
Not.
We just saw the 32 which speaks of all the assignments.
Yes. I think
Well, I just kindly appreciate
But page number 40, 12150 square meters, that is not 1 hectare.
Let's first see this document and we'll come back.
My lord, the recovery certificate starts at 38.
Yes.
38 is the recovery certificate by the DRT Karnataka, Bangalore. Lordships have seen Canara Bank, my lords. So therefore, the due amount of Canara Bank, my lord, is around 34 crores. 95, is it? 34 crores.
34 crores.
That is only just Canara Bank. Total today is 9896
crores, correct.
of all. Now page 40, my lord, is 12150 square meters, which is equivalent to 1 hectare, 2120, and that is also registered in ROC. And my lordship may take it. All memorandums are this figure only. All memorandums.
Yes, which page?
Because we have been assigned loans by 5 entities. One of the entities we have been assigned loans by is a corporation called SCICI. I have the assignment deed from SCICI to me in my favor, but just now see the memorandum of entry for SCICI, which is annexure P51, page 40. Lordships have. Can I read the whole thing or just I just focus? Yes, because page 42 bottom. Shri so-and-so Hegde on the same day accorded and gave oral consent on behalf of company to Shri so-and-so, Assistant General Manager Legal, acting for KSFC, KFC acting as agent of Canara Bank, and Canara Bank acting as trustees for holders of 9,50,000 21% secured redeemable non-convertible debentures of 100 each of an aggregate normal amount of rupees 9 crore 50 lakhs to hold and retain the said title deeds as and by way of mortgage by deposit of title deeds by constructive delivery on company said immovable properties, namely plot number so and so, 1 hectare and 2,021 square meters at Pina Industrial Estate so and so. And the schedule, Milos, also mentions this at page number 46. So our mortgage deed, because is clearly, Milos, at page this 40. This is only one mortgage deed. I have placed on record. There are 6 mortgage deeds executed for 6 entities, and I have got an assignment in my favor from this entity. Because I have placed the ICICI Bank assignment. Well, I have another deed, your lordship will see at page 60 from Fuji Bank, page 60. I am also the assignee of Fuji Bank. Page 60, your lordship will have.
There is no notice on this. You have not put any.
Memorandum of entry for extension. It begins with that. Lordship may straight away come to para 3. Shri A.V. Hegde on the same day accorded and gave oral consent on behalf of the company. So and so sales a Fuji Bank. Yes, madam.
One submission. My learned friends SLP, there's no notice. There is a leave to file an appeal. And there's no notice until now. No, I do not have any opportunity to deal. I'm being given instructions.
I don't notice has been ordered, I think.
No. Still permission is not given to file SLP.
No, implement is different. Just one second.
Still permission is not
Notice was issued, I think. Just give me 1 minute.
You are mistaken.
Notice.
Dated 25
Yes,
10
yes. I have the order.
Permission to file
SLP granted. I appeared, I think.
And tag with.
So, my lords, then my lords, can I just take instructions? Because they have instructions on this. My lords, let me just come
We are
back.
not closing the issue. The writ petition which was entertained on the basis of only IFCI's document, ignoring the details in the 13-2 notice and the fact that the other secured creditors have documents showing that the security interest was created in the total extent of 1 hectare, 2,012 square meters. So that the High Court was wrong in proceeding on the incomplete facts that were before it. It ought not to have entertained the writ petition.
So, my lords, I'll give
Therefore,
only
we will
one.
say that on that ground, the writ petition and the writ appeal are
Very
liable
well.
to be.
I see what my lords have put to me.
Matter is that left open for those who are aggrieved to approach the DRT.
Correct.
Whoever wants to ask for whatever relief, you want to go for a recovery certificate, you want to go for a 17, do that.
Yes.
My lords, only one aspect.
We are not
My lords only take
saying
my.
anything on my.
No, only, yes, this is on this aspect what my lords have put to me, only answering that, and thereafter my lords may, if my lords are still not satisfied with this submission, my lords may proceed with that. My lords may take my counter affidavit for a moment on behalf of Maruti Technologies. With my counter affidavit, I have produced another assignment deed. Now, there is this one assignment deed that is there before my lords, which refers to only 2,012 square meters of land. Please see with this counter affidavit at page number 18. Now, my lords, please see this. Now,
In the additional documents, page 18.
no, it's a counter, it's a counter affidavit.
Filed by Chandrasekhar.
By,
This is IFCS.
no, my lords,
Assignment.
Affected for respondent 14 to 26. H. Chandrasekhar.
14 to 26.
yes, my lords. Now, if my lords will take this assignment agreement.
This is the one which is actually upon by. IFCI to Phoenix Arc.
My lords, IFCI to Phoenix Arc is a subsequent one. The first one is IFCI. IRC.
IARC. Can I just sorry.
1 minute now. This is my lords. So what has IFCI has done? It has done one assignment of 2,021 square meters, and then it has done a second assignment under this particular agreement to Phoenix Arc for 1 hectare. Yes, my lords.
And entered into one-time settlement.
And thereafter, there was a one-time settlement between the Phoenix Arc, and that is how we come into picture.
It's not just one bank there. The 13-2 notice itself indicates that it has been issued on behalf of several secured creditors.
My lords, therefore, what I am
submitting. You can't say that I settled it with one person.
My lords, I didn't. The predecessor in interest. I am a purchaser under somebody else. But what I am trying to say is, IFCI had the original title to, let me say, 1 hectare and 200.
All of them had mortgages. All the banks seem to have had mortgages. So we don't
Mala,
know
just
Manoj, I am sorry, the other banks are claiming together with them. They will.
Is that 32 notice which
Yes.
Minus 13 to 2013, just minus, just in 2000, my lords, just have a look.
My lords will see page number.
One can look at the 13.
Yes.
Which page was
My lords would be at page 239.
239 if you're
239 in the first SLP.
kindly see 239.
And thereafter, there is an OTS at page 759 in my guide to that.
OTS with one person, when there's so many people involved there.
Malord 239.
39.
Malord 239 and kindly go at Malord 242. Lordships have 242, Malord. Para 7.
Yes, my lord.
Under these circumstances, IAR, sorry.
My lords have 39. My lords have that international.
The following amounts within 60 days from the date of receipt of this notice, 183 crores as far as IARC, Canara Bank 89 crores, 81 lakhs,
But what
IFCI Limited.
Notice is issued
No, my
on
lord.
behalf of the secured creditor.
But just see page 239 and 40 for a minute.
Yes.
Please come there. We international asset, please leave that. Assignee is IFCI. Hereby issue the notice in capacity of a borrower. Now come to paragraph 2, my lords.
At the bottom. At the bottom.
Yes.
On behalf of
secured now.
creditors.
Now please see.
Who are the secured creditors?
Now, Canara Bank, IBI, since assigned to IFCI. So Canara Bank had already assigned to IFCI. United Bank since merged with IDBI. Industrial so far transferred to so and so.
So different entities there.
No, my lords, what I am trying. So my lords, what I am trying to say is, my lords, what I am trying to say is, when the International Asset Construction Company takes it, it can only take what has been assigned to it. Now, what has been done by IFCI is, IFCI has created 2 assignment documents. One is
ignoring the others in this para 2, Ms. Aruna.
My lords, I've seen there are others which are mentioned there.
There are a whole lot of others.
No. But my
all those are there. There's no question of.
But my lord,
IFCI is the whole and soul, and IFCI settled with Pegasus, and Pegasus settled with us. So
my lords, only the thing that we are missing out. No, we are missing out one significant aspect. International Asset Construction Company is the assignee of IFCI. So my lords, it gets what IFCI assigns to it. What I am trying to tell my lords is, IFCI entered into 2 separate distinct assignments. Now, my lords, IFCI assigns their remedies against IFCI.
all of you, your remedies are there.
And just one submission, we'll just place some documents. Madam, just one submission. Madam, this assignment, madam, this 13 to the 2013. We'll just say.
Nothing which remains to be decided here.
Madam, just kindly.
There were too many disputed issues which were not even in the knowledge of the.
Just 1 minute. Just 1 minute, my lords. This OA by Sprite minus in 2000 refers to 2012 hectare square meters at page 147. Just have a look, my lords, at page 147. At page 165 recovery.
That's
one which doesn't mention.
Just give me
only the schedule the body has.
No, please see. Wait, once recovery certificate again refers, my lords, at 2012.
That is
Post 13 to notice dated 2013. Prior to that, IFCI enters, my lord, in the assignment deed. Again, please see, this is an important document. Please see. No, my lord, this, my lord, just kindly appreciate. This 32 notice is 2013. Prior to that, my lord, just me here.
This is not a case where
we are bona fide purchasers.
You are not welcome to remedy.
No, my lord, just see one document, just one page, my lord. IFCI, my lord, in 2008 enters into an assignment.
I already just told you IFCI is not the only secured.
Minus, but they were sleeping. This is 2013. They are getting out, and my lord, just kindly appreciate from 15 years they were sleeping, my lord. Minus, the proceedings granted.
These.
My lord,
your SLP is also in the same model.
Yes, in the same model, lordships have already permitted me to file.
My lords, only one request. At the time when my lords had issued notice, We are subsequent purchasers.
My lord,
My lord, our documents will be protected.
my lord said in the first order, my lords. Just have a look at the first order. Just to, that we would be protected, my lords. Just, yes, yes.
Said on the first day that purchases will be protected.
And my lord, the only other thing that I would request my lords to look at is that if there are 7 documents.
Just give me a moment, my lord.
Issue notice.
There are 7 documents that say 212 and one document is one.
It's an oral observation, my lords. I'm sorry.
No, it's not there. It's not there. That's why we are shocked.
My lords, I was only submitting, if there are 7 documents at record, 212. One document says 1 hectare and 212, which one, my lords?
This also they're producing after 15 years, my lords.
And mistake everywhere.
My lords, just one date, my lords, I'll leave it to that. This started in 2000, my lords. This 13 to notice 2013. Prior to that, my lords,
Already said that, Mr. Kaushik.
my lords may have it next week. My lords will place some documents on record, my lords.
We are
My lords, they-
more than satisfied with this section order was completely uncalled for because the High Court did not have the full facts.
No, because the High Court couldn't. My lords, there is a reason because these are all old proceedings. They did not brought anything on record there.
They don't raise this issue.
Financial institution.
There's all new arguments over here, man.
Judgment later.
My lords, may I say one thing here? We have all put up construction. No, we have our own industries now on those plots.
Small businessmen, my lords.
We have small business people there today.
Dated 5th June 2024. As per a division bench of the Karnataka High Court in writ appeal numbers 231 and 230 and 231 of 2024. By the said judgment, the division bench held in favor of the respondents on the ground that the property mortgage to be secured creditor in the International Asset Reconstruction Company Limited was only an extent of 2012 square meters and that it had no rights over the larger extent of 1 hectare. However, perusal of the
That's me, I'll be excused.
Yes. Perusal of the notice issued under section 13 within brackets 2 of the securitization and reconstruction of financial assets and enforcement of security interest act 2002 for short footnote issued by the International Asset Reconstruction Company Private Limited shows that it did so in its capacity as a trustee of IARC-EIN-04/807-08 trust on behalf of the secured creditors. The details of the secured creditors were mentioned in paragraph 2 of the notice, and we find that several banks and financial institutions mentioned therein, apart from the IFCI Limited, from which the International Asset Reconstruction Company Private Limited was claims an assignment. The documents placed on record by the Kotak Mahindra Bank, the appellant in the second appeal on the appellant in one of the appeals for us demonstrates that the security interest in favor of the assigners of the said bank was in respect of the total extent of 2012 square meters and was not limited to just 2012 square meters. Now the council is waiting for the International Asset Reconstruction that we have also mentioned. Would assert that
though the schedule in the document pertaining to IFCI Limited was erroneous in the though in the schedule of the document pertaining to IFCI Limited, there was an error with regard to the extent of the land offered as security interest. He would assert that the body of the document indicated that the entire extent of 1 hectare, 1,012 square meters was covered. So stop. Be that as given the above stated facts, we are consider the opinion that the High Court did not have all the necessary full and necessary facts before it.
No, they did not place it on record if at all.
For exercise of jurisdiction under Article 226 in a matter arising under the Surfacey Act, the High Court would not ordinarily exercise jurisdiction unless jurisdiction under Article 226 of the Constitution, unless patent illegality is made out. As that was the impression under which the High Court proceeded, but on the strength of incomplete and incorrect facts, facts, we are constrained to set aside the order dated 5/6/2024 as per the High Court. All issues are left open for the parties to address before the appropriate forum address of their respective grievances.
And just one submission, we are going to just protect us, my lords.
Allow to the extent.
Well, it's in the 1 hectare. My lords, we just in the meanwhile may protect me, my lords. They're all small startups, my lords, in a 1 hectare.
You file your application under Section 7, ask for appropriate.
That lordships have recorded at one document, it will be various documents.
Sorry?
Lordships have said, I've stated one document, it's various documents.
Various documents.
Because I don't want to say
assignment.
because the assignment didn't have assignment, but is.
Various documents pertaining to IFC.
Wait, at least this possession may not be demanded. We will be in a defeat.
You filed the application under 17. Ask for interpretation.
But still then at least they may not do anything.
I'm not going to say anything.
At least give me a month's time, my lords.
Nothing.
Manage for 3 years, we paid money, manage all small, I would not have
You
insisted.
went before the wrong level.
No, manage, these are all pending industry.
That's Section 13(2) notice is clear.
13(2) is 2013, prior to that always was 2012 hectare.
Sorry, you're not going to.
It's all new startups, if my lords would just consider, my lords.
Nothing.
Anyhow, my lords have said all the contentions are left
All
open.
issues are left.
Very
good.
Milord, this is that Siliguri matter, Milord, where lordships need to.
Fresh terms and conditions.
Yes, Milord, nobody has filed any counter affidavit. There is no objection from the other
They
side.
can proceed with the auction.
That's
So
right.
we
Lord,
can
just
proceed with
kindly
this,
ask,
Lord.
one of the orders, Lord, which was earlier passed by the division bench. Lord,
Proceed with the
the 4th of February order, Lord, they were detailed, Lord, directions which were earlier given, Lord, may just kindly have that. All that money has to come here, Lord, whatever the money that they get, because this will be the third auction, Lord, now. First auction, Lord, held about 2 years back.
The only change which I am requesting for is that instead of 50 crores, Milord, it should be 40 crores, Milord. Reserve price.
40 crores, you will be reducing the reserve price.
And we may, second, Milord, that we may be permitted to hold even an e-auction, Milord.
E-auction.
Yes.
The 4th of February order was a detailed order which was passed.
Because we are bound by the daughter.
That's what all I'm saying. That's right, Lord. That says 50 crores, but I have no difficulty with 40 as well. As far as the money comes here before this court, so that I'm secured.
Yes, yes, money will come here.
8th of April is one order. What will be 4th of February?
4th of February, Milord.
4th February 2025 minutes. 4th February minutes.
They are not putting up the ground button. 8th April is there. 10, 16. We have
We can
third
pass it, Malos. We have the order copy.
3rd February is there. It says list on 4th February.
Malos, I am passing the order. Please take 2 copies.
Yes. You also go.
Because may I read the order?
Yes.
Because it says, having regard to the peculiar facts and circumstances.
Don't read the whole thing, just tell us. which
Because
part
the
is
first,
relevant.
this page number 2, Milords, it says A, Milord, in bracket, each interested party shall deposit 50 crores with a.
Now that will come down to 40 crores.
Not one thing on that, Milord. There's already a bidder for 400 crore rupees, 40 crores he deposited with the High Court.
That is the earlier bidder.
That's right,
The
not
one
before.
who's there in the background now.
That's right now. Now, Milord, they came up before this court.
Who's appearing for him? He's not.
Milord, last time also they were not here. They're not a party as well, Milord.
He's not asked for return of the money.
He doesn't need it, it seems.
Mr. Trivedi.
No, well, they have not asked for any return, etc. But they will be participating. They might be participating.
The money is still there, Milord.
Money is still there.
Money is still there. So, Milord,
he's deposited 40 crores only.
yeah, Milord, because he was the successful bidder before the single bench.
Now anyhow they want to bring it down to 40 crores.
So on that, Milord, I have one thing to say, subject to Milord's, of course. Milord, now what happens is they came here before this honorable court saying 400 is not enough. So, Milord, after 400, there has to be a much more amount. That is why the honorable court said, Milord, earlier the order says 50 crores. Milord, I have no difficulty. Otherwise, I just wanted to put across.
See what comes now.
That's it. And Milord, this is the third bid. And Milord, if now also nobody comes, Milord, first bid 2 years back, nobody came. This honorable court order
will ask the successful bidder to take it.
Grateful. I'll be grateful.
My lord, I filed an recruitment application, my lord.
What do you know?
But I was one of the bidders in the earlier occasion, my lord.
SLP has been dismissed, Lord.
My lord,
SLP is dismissed.
Absolutely, my
Oh,
lord.
you're the one who's SLP.
Absolutely, my lord. I have disclosed that in my application.
You didn't deposit.
I couldn't deposit at that time, but I'm.
Now you got the money.
Please, my lord. I am willing to.
40 you got or 400?
No, my lord. The honest money deposit.
So again, you'll make a bid and then run away.
No, my lord. I want to participate in the bid process.
Participating is all right. See, EMD.
Please,
40 crores is the EMD.
Yes.
After that, you have to cough up the rest, whatever you pour.
Absolutely, my lord.
There's no point in crippling the whole process and again running away. You ran away last time.
We are not intending to do that.
So why should we allow you to again run away? Anyway, if you participate, you participate.
He can very well participate. It's open bid, Milord.
We are informed that.
The only other change will be in clause G, Milord, instead of this open auction, e-auction.
No objection has been received vis-a-vis the fresh terms and conditions proposed by the Siliguri Jalpaiguri Development Authority for conducting a fresh auction. In that view of the matter, the authority is permitted to hold the fresh auction by reducing the EMD amount to rupees 40 crore. The authority is also permitted to hold the auction by way of an e-auction. Now, earlier we had asked Ms. Garima Prasad to.
That may not be necessary.
The process has already completed.
She can still be there, Milord.
For what reason? For an e-auction?
Now, what happens is, Milord, my apprehension is what happens is, Milord, 2 years back there was an auction, then there was an auction. Nobody even.
You already paid her the amount due for the.
That was paid, Milord. Well, let her be appointed, Milord.
Yes, Mr. Trivedi.
I have no problem to her appointment, Milord, but.
I don't know whether she would be available. When you propose to hold the auction?
And since it is an e-auction, Milord, it will not be necessary to go.
Sorry?
Since it is an e-auction, Milord, it may not be necessary for her to go, Milord.
That's an e-auction anyhow. What is it? There's no need for her to again go on with. When do you propose to hold the auction now?
Lord, the rest of the term will follow, Lord, within 15 days. Your Lordship had directed that we will advertise.
Is proposed to be held within 2 weeks or 3 weeks?
3 weeks.
3 weeks. Within 3
Within
weeks.
3 weeks, we will advertise, Lord, then we'll complete it in next 3 months.
Oh, 3 weeks and then 3 months.
Yes. And we'll have to advertise, Lord, then complete it.
Process for you to finish the whole thing.
But can the decree holder be present there? Can I be?
The auction process will be initiated.
shall be initiated within 3 weeks and completed as expeditiously as possible and preferably within 3 months. List on January 2020. And was the opening? 15th.
Because they'll comply with the order. They'll comply with the, the order I referred to, 4th of February.
What are the aspects you have to be?
In fact, there was a detailed order which has been passed.
Which aspects do they have to comply with?
Not all of them, in my humble. Apart from G is not the
fresh terms and conditions have been placed on record.
Those are the terms of the lease, but can you kindly have this, These are the terms of the auction,
You will be abiding by the same conditions.
Yes.
The terms and conditions mentioned in the earlier order dated 4/2/2025 shall be reiterated and shall be abided by, adhered to, and shall be adhered to during the fresh auction process.
Grateful.
But if they fail this time also,
That is why we anticipate that they'll fail.
But this has been happening 2 years.
If you wish for something negative to happen, that may happen also. Why mock fate? Let us be positive, and hopefully you'll get a better price. You need to get money.
No, mine is only 200 crores. Mine is only 200 crores. Rest is their money. Please.
One aspect of the adjournment letter. Those matters can be adjourned so that they don't clutter up the list next week. Only item 76 says an
Yes, my lord, I am from 76.
What is that matter about?
My lord, I tell your lordship, my lord, only thing, we want the portion of the order that has not been modified by your lordships.
Which portion?
My lord, the publication of the Weimar sheets, my lord, refund of salary, and my lord, tainted candidates are being allowed to see even after.
That will be taken care of.
My lord, even after your lordship, Friday's order. Friday's order, my lord,
It will remain in the list. Item 76 is not going to reach anytime soon. So you don't need to worry about that. The other matters, item 47, then counsel for respondent number 3 seeks an adjournment on the ground that the arguing counsel is held up before the Constitution bench. List on 4th November. Then item 56, the counsel for the respondents filed an letter seeking an adjournment on the ground of personal difficulty. List on 28th October. Then item 60, counsel for the petitioner seeks time to bring the legal representatives of deceased respondent number 3 on record, list on 11th November. 61, counsel for the petitioner seeks time to file a rejoinder, list on 18th November. Then 63, counsel for the respondent seeks time to file a counter affidavit, needful in that regard usual order. Yes. Then list on 18th November. Then item 70, counsel for the correspondent number 1 seeks time to file a counter affidavit, same order, 18th November. Then 71 also, counsel for the respondent, same counter affidavit, list on 25th November. Then 76, don't say anything. Any other?
I'm appearing in personal laws in item 48. It's a matter of overarching in personal custodial torture.
You have to wait for the matter to reach.
No,
now that some matters have gone down.
I have very small request. If the matter comes up next week on Tuesday, I have no difficulty. I have difficulty because only thereafter till 15th October. It can be taken up any time after.
Let us see how
if it comes,
will be next week.
Thank you, Lord.
Next Tuesday, let us see what its position is.
Very well.
If it is not reaching, perhaps you can make a mention or get some friend of yours to make a mention at the
overarching in press clause 2016 matter.
I remember you made a mention before.
I've made so many mentions.
So anyhow, because we've already instructed the registry not to add matters over the matters which are already listed unless they are vague matters or transfer petitions or fresh matters.
So we'll take
hopefully these matters will start winding up. If any matter is added out of turn, please let us know so that we all up the registry to find out why they did it.
We'll take if it doesn't reach 9, then I'll request you make a motion.
Well, at item 76.
Anyone else wants an adjournment? We'll make a motion. If you want to climb the ladder, that is not happening. Extension does not arise unless the matter is taken up for hearing. Have we taken up your matter for hearing? Then why do you need an extension?
May I mention item 64, right, can be disposed of by consent of the parties, other side.
Item
64, it's respect of appointment of an arbitrator. To both the parties.
Appointment of an arbitrator should not be coming before us. Why would it
The
come
High
before
Court
us?
had.
It's a 11 application or something
No,
else.
no, the application under section 8 was dismissed by the High Court. Rejected by the High Court. I think
Now
that
go
was
to
the-
your
Yes, because,
consensus.
yes.
So I am appearing for the respondent in that matter. The High Court has already appointed one of the arbitrators in another matter concerning the same party, his wife and my client, Your Lordship.
So what, are you now agreeable to an arbitrator?
Same arbitrator can be appointed, Your
Yes,
Lordship.
Lord.
Same arbitrator.
Lord, if your Lordship will kindly see the IA number 166322.
It would not have come also. It would not have
60.
It wouldn't have come also.
Can you Lordship have it on Thursday? It's possible to dispose of.
Make a mention next Tuesday in the morning, so that in the event the file is not done, we'll call for it. You can ask for the matter to be taken up.
Lords, item 30, may I mention?
What do you want?
Lords, on next Tuesday, I have a difficulty, only on next.
Then if you ask for an adjournment, you'll need to leave the date to us. You can't ask for an adjournment and say it will be as per my convenience.
Lords, only on next Tuesday, ma'am.
64 is here. 64 is here, Council. Yes.
Lordship, item number 39, Your Honor.
Oh, 64.
64.
64, Council. Is 64. Your file is here.
Kindly see volume 2, IA number 166322.
Volume 2. I number 166322.
322. Yes. And your Lordship may kindly see page 13.
13.
Yes, para 23.
Yes.
Under similar circumstances, the Bombay High Court has appointed Justice retired Anil Menon. Same arbitrator may be appointed in this matter also.
Granted. This appeal arises out of the order dated 2/3/2023, passed by the which High Court is?
High Court of Bombay.
Bombay High Court in arbitration application number 75 or 21999? Why there's so many numbers mentioned?
75 of 2023, and then the review petition is number 3 of 20.
Arbitration application number. What is this L number then?
Lodgement number.
Lodgement number. Then the regular number is 75, is it?
Yes. Both have.
Arbitration application number 75 of 2023 within brackets arbitration application again within brackets L number 2199 of 2022 and the order dated for 2 appeals. These appeals arise. And the order dated 14/8/2024 in review petition number 3 of 2023 in arbitration application number 75 of 2023. During the pendency of these appeals, the parties here too have come to an understanding that the appeals can be disposed of directly, that the disputes be referred to the arbitrator who has already been appointed in relation to some other disputes.
In some other disputes.
In relation to some other disputes between them, in the light of the consensus arrived at by and between the parties, these appeals are disposed of directing, appointing Justice within brackets retired Shri Anil Menon, former judge of the Bombay High Court, as the sole arbitrator to adjudicate upon the disputes and differences that are the subject matter of which suit.
Lordship, commercial arbitration application number 186.
Commercial arbitration. This application was filed in some suit, is it not?
No, Your Lordship. This is a fresh 11/6 application they had filed.
It's 11/6 application.
11/6 application.
This order which is filed, placed before us.
The impure order, Your Lordship, or the.
This is a 11/6 application.
11th.
Then the arbitrators being appointed in relation to which
that is
arbitration agreement then?
Page 5 is the of the IA.
of the IA.
Page 5.
Is the High Court's order in which the.
No, this is the other appointment.
The appointment.
We are asking you about this present appointment. We are making the appointment in relation to which?
Page 23, my lord, is the agreement of in the main paper SLP paper.
Page 23.
In the service act.
Section P1.
Appointed as the arbitrator to adjudicate the disputes arising out of the service level agreement dated 2/2/2021 in terms of the arbitration agreement contained therein in clause number.
It's quite the line, your lordship.
There's no arbitration agreement.
There was no
clause.
subsequent.
Subsequent agreement.
Page 27.
Yes.
The first two lines. Agreement shall be always subject to the exclusive jurisdiction of the courts and arbitration. This was the initial.
In terms of the arbitration.
It was later on different.
Clause. What is that clause number?
7.
8 is it?
Sorry, 8. I'm sorry.
In
8.
terms of clause number 8. Later. The arbitrator will be entitled to fees in terms of schedule 4.
Not in item, not in item 6, an infrastructure project that is national highway that has been stayed by the highway.
If you are asking for an expeditious hearing, Mr. Sangwan, you'll have to wait.
So not by taking next week.
It will remain in the list, hopefully it will climb. You'll have to leave it up to fate.
Well, that's item number 13.
Applies to all those who are asking for.
Look, so I'm not asking for
2 weeks of time, Your Honor.
Look, next Tuesday I have a difficulty.
Make a mention if, oh, I see, you have a difficulty, then we'll adjourn it.
Very good.
Which item?
Look, item 30.
30, I want.
30.
I'm the
item 30.
So I'm the respondent in 30 minutes. If he has a problem, then I won't object to some short date.
The matter is according to adjourned.
Some short lamps.
On 28th of
Well, it's item number 39. Only grant 2 weeks of time, Your Honor.
Which item?
It's number 39.
39.
Petitioner, Your Honor.
Anyone?
I'm up here for
no objection. No objection. Thank counsel for the petitioner 6 in adjournment based on 4th November.
Please, may I mention item number 72? We received counter yesterday and it's taking 4 weeks time to file a
It may not reach for another 2 weeks at least. If that is not sufficient, you can renew your request.
3 weeks then. Kindly this matter after 4 weeks.
We'll go slower then to suit your convenience.
Okay.